The opposite party number 200. Opposite party, who is the petitioner? Petitioner Mr. Mahanti, Sanjeev Mahanti. Note to the yes. Published. Yes.
My lord, item 15, my lord.
Item 15, yes.
My lord, I am appearing for the informant, my lord. And it will be taken up any date after the vacation, my lord.
What is this matter is about?
My lord, this is bail matter, my lord. Books.
Informant, wait. The petitioner has to come. And a bail matter, how can you ask for adjournment? Yes. Who is in custody? Yes. Wait. Yes. Yes, reserved.
But in this case, this is an application of 482 to pause the proceeding, criminal proceeding under the prevention of criminal.
Yes.
The lordship the other day had called for the report. Essentially, I am challenging the prosecution on two grounds. That is, one is inordinate delay.
You wanted to file some additional document. What? Yes. Yes.
A report in Flag C, madam.
Huh?
Flag C had called for the report.
Flag C.
Report. And so why the matter is pending for 23 years?
The court is asking for 4 months to dispose of the case.
My lord, if your lordship appreciates, my lord, I have annexed the entire order sheet of the court.
Like this is in between the trial. Many witnesses have already been examined, and they say that give me 4 months, I'll conclude the trial.
Well, that is after, that is before charge, my lord. Section, this Prevention of Production Act, my lord, the magistrate has committed an error by resorting to warrant procedure. The trial has to be done in summary procedure. So, question of
Pre-summoning evidences were recorded. 3 witnesses were examined. Pre-summoning.
yes,
And thereafter summons were issued. And these 3 witnesses are to put to cross-examination.
Total 4 cases.
So that is what the case says to give 4 months time. I can't scuttle the trial.
my lord, your lordship will appreciate, my lord. The prosecution was instituted in the year 2000.
I know.
And till date, my lord, even after
I tell you, sir, if a court is asking for 4 months, we should generally give 4 months. If it doesn't happen, then
I bow down.
final opportunity 4 months time is granted.
I bow down. That one more ground is there, which I believe, my lord, your lordship will be inclined to interfere. In this case, my lord, the chances of conviction is very bleak. So therefore, why I say mandatory prison under section 13(2) has not been complied. My rights to
All these points you can very well argue.
My contention, my objection, my kind ship to same point raised before this one report. Initial 252. All these things. They are this one report. Directed the trial will conclude for within 4 months. And by the time one would so
that was in the year 2010.
by one would second by the time.
And you are
I understand that. Very that.
My page 22, madam. Cognizance taken in December 2007 and in the meantime 10 years having a pass.
1 minute. I'll just let me.
Page 22. 22, madam.
Page 22.
Madam.
yes.
Yes.
Other than 9 words.
Yes.
But by then 10 years had passed. After this order, my lord, the trial court did not
And
take any
right,
steps.
right down. Persons to the order dated 13/9/2024. The 24, the what is that? 24, the SDJM Kunjar on 19/9/2024 has report which reads agenda flat fee. Agenda. Mr. Ragoda has Mr. Ragoda has pointed out that the same petitioner had approached this court by filing CRLMC number 2534 of 2010. This court, by the order dated 9/12/2010, targeted the trial to conclude within 4 months' time. 4 months' time. 4 months' time. It is next paragraph. It is surprising that despite the order dated 9/12/2010, targeting the trial to be concluded within 4 months. 4 months, the trial has not yet been concluded. Rather on the contrary, the Leonard SDGM Kunjar wide the letter dated by the letter dated 19/9/2024, seeking 4 more months to conclude the trial. This court is expressing displeasure on the manner in which the trial in the present case has been carried out. Be that as it may, since the Leonard SDGM Kunjar has sought for 4 months time, I am of the view that by way of a last and final opportunity, 4 months time from today is granted to the trial court to conclude the trial. And it is made clear that no further extension of time shall be granted in any manner, on any ground whatsoever. Accordingly, with the above observation and direction, the present petition is disposed of. Yes, sir. Last opportunity.
My lord, one more submission.
Yes.
So far as this delay is concerned, my lord, I believe, my lord, the Leonard SDGM must not have explained the delay. Why?
He has
not explained.
I have reproduced that.
My lord,
Please.
so
I have exposed the displeasure also.
therefore, my lord, I just want to bring your lordship notice a judgment of this honorable court, where this honorable court has held that unexplained delay, delay, the petitioner should not suffer. So that's one point which I want to submit. My lord, recently, my lord, Supreme Court also have held in Hashmukhlal de Vora.
But in the same time, Supreme Court has also said that you can't scuttle the trial in the
Well, that has been
trial.
dealt with in this case, my lord.
But I have passed this order. I think this is the 4 months final opportunity. No further extension. You have a very good case. You will be acquitted. What is the There's not
This is trial is on before charge. Ma'am. After charge, witnesses will be there.
That's their problem.
Only for witness.
That is their problem.
That is the petition. Only 4 witnesses, which took 23 years.
That's right. I can see that. So I have expressed displeasure. But once I sought for a report, and the magistrate says that please give me 4 weeks, and we should not disrespect the report also.
That's all right, Malak, but the liberty of the petitioner is also the.
I think it's to be seen. I think it is the balanced one. Okay, thank you. Yes.
Item 2.
My lord, item 2, my lord, I am appearing through VC, my lord. We have sought for some document.
Liberty to file a discharge application there.
No, don't do that. Don't do it. Rather, you can move an application under 205 for exemption. That
I am on bail, my lord.
You are in bail, exemption also you can seek. Learned counsel for the petitioner at this stage says that he has suffered the trial for about 23 years. Facing the rigors of the trial, he is harsh on his part. So therefore, he seeks an exemption from appearing in the court and to face the trial through his counsel. He can liberty granted to the petitioner to move appropriate application before the trial court. If such application is moved, the same shall be considered. You move application through the consider.
I have been appearing, my lordship kindly sees the order sheet on each and every.
I have seen it is very hard case.
Each and every day I am there,
Yes.
but and I have heard the complainant has died in the meantime. I don't know that.
Oh, see, I'm looking into all these things. For 4 months, I applied and don't go to the court and do 205 application. Yes.
They have already filed for discharge, my lord. 20,
I know what is not. Yes.
item 2.
My lord, item 2, I am appearing through VC, my lords. My lord, we have sought for some documents from the learned court below, my lord. My lord, may take it up after vacation, my lord.
You have sought for document from the court below.
Yes, my lord, applied for the certified copy due to shifting of the new court in Bhubaneswar, my lord. The file is untraceable, so it's taking some time.
You want to obtain some document from the court below. You have not
Yes,
sought. You have not sought.
Yes, my lord. I bowed down, my lord.
Okay, it's all right. Adjust.
Item 3.
Grateful.
Yes.
Well, in this case, there was a technical hurdle which your lordship had pointed out. There was an order of this honorable court because this is for, I've come up against an application refusing discharge, my lord, order refusing discharge.
Yes.
My lords, this honorable court had directed by a previous order that expedite the trial. Subsequently, this honorable court has also directed that we are at liberty to move all our points before the learned magistrate for discharge, and thereafter he is to consider all the points, decide.
First order is to expedite, second order is to permit order. Yes.
So, my lords, in view of that order, I raised all the points, and my lords, that has been dismissed. This order is dated 8/8/2023 by Justice D. Das, wherein he says that in course of hearing, learned counsel for the petitioner prays for withdrawal of this revision, seeking liberty to raise all necessary contentions at the time of framing of the charge. Granting this liberty as aforesaid, the revision stands disposed of as withdrawn. So this liberty was granted to us. In pursuance of this liberty, we have raised all our points before the learned magistrate. He has dismissed it. It will take some time to hear the matter, my lords. Your lordship.
List it up. List it up.
Item 4.
Obliged.
Yes, please, my lords. Lords, petitioner challenges the order dated 27/2/2024, my lords. At Annex 2, my lords.
Yes.
Petitioner was released on bail, lords, by order dated in 2016, my lords. Lords, his passport was surrendered in connection with the case, my lords. In the meantime, he wants to visit his son who resides abroad.
Son to visit, son?
Who resides abroad.
Where?
US, my lords. And on the pretext of flight risk, my lords, my application has been turned down. Charge sheet has not been submitted yet.
What flight risk?
Investigation is done more than 1 crore is the bank guarantee.
No, you furnish bank guarantee and go.
Lords, lordship may directly, I'll furnish property security to
Bank guarantee, you give bank guarantee and
I'm not the assaulting accused.
bank guarantee for 2 months. I will allow for 2 months to go.
Lords,
And give the bank guarantee, come back and guess it.
lords, and my humble suggestion, lords, entirety would be a bit hardship. Lords, there are other accused persons. Lordship may equate that and lordship.
Sir, investigation is still going. So, go. There may be a problem in
Case of the year 2013. I was my lords. Apprehended in the year 16, my lords. Released on bail in the year 16.
They are none of the accused persons.
What is the allegation against him?
Because the branch manager, he granted loan in respect of on the basis of
Lords,
respect number of persons.
Let him go. Let him go.
I don't want to. Because thing is that let him request some bank guarantee, with the detailed address.
Well, I'll give the detail, address, detail particulars, that is there before the court will arrive.
That you will give your itinerary and all.
My lord,
Where you will say, give
bank guarantee, my humble friend, bank guarantee may be a bit less. How, sir?
is the
1 crore 30 lakhs is the.
1 crore 30 lakhs. But he is not involved in liability because.
He is responsible, he is the branch manager without his connivance with capital.
But then how much bank guarantee is it? 50 lakhs?
30 lakhs.
And he knows it.
Retired bank employee, so 30 lakhs.
Bank guarantee for 2 lakhs. Bank guarantee 50 lakhs bank guarantee. Yeah? For 50 lakhs bank guarantee. And normal order में कर दिए order ठीक allow 2 months from the date of release you go and give your detail like itinerary will give and wherever you are staying and with all detail will give ठीक है हाँ
B must be able to
हाँ
calculate the पूरा.
yes
50 lakhs.
I will take the order yes
Baki
You have the right to go and attend his, but he employee whether he can raise that money or not, I am not sure. He has the right to meet his son. And are you sure that your client can manage 50 lakhs?
That is why I was suggesting it's 30.
You don't say anything without asking your client.
So Lordship will pass that order or else I will.
And you move an application for modification. You seek instruction if you want. I'll put it after.
Lordship will pass.
No. What I'll do is I'll pass it over.
Well.
Just see. Otherwise, see there is no point passing an order which can't be executed. Unnecessary. So he's employee. After all, bank employee, how much he will be able?
I'll take instructions and
At 2 o'clock, I'll pass this order.
well,
But
I'll appraise.
and then for sake of saying, don't say.
No, I'll
You can afford it. And they can afford it, let him give.
let him one pass over.
That's what I'm saying. That's what I'm saying. I gave that leverage doesn't mean that I will reduce the amount, but if he can afford, and he's not giving, for 2 months bank guarantee will come. Then that's it.
Well,
Okay.
Item 6.
May visualize.
Yes.
Whenever I have challenged the order passed by the Reliance Specials is vigilance, rejecting my application, filed not to frame charge, my lord. Here, the case is like this, my lord,
You move the application for discharge. We will turn down.
which was rejected.
Yes.
But at the facts of the case is, in the year 2007, there was a epidemic, there was breaking up of an epidemic at Bhavanipatnam, my lord, Kalahari district, for which my lord, the government took a decision to install electrochlorinators in all.
May service from the Lordship turn to page 86.
86.
Page 86.
Let me complete.
Yes.
Page 86, then the Lordship, page 86, there is second accused also Ramesh Chandra, which petition in this case. If you turn to the next page, the person was not finding
Prashant Kumar Panagre. Yes.
Yes, fine, challenging same orders. 549 or 2020. The another case is also there. So I'm giving all the cases from a challenging same input orders. Can be taken up. And we need a what instructions a bit bulky one. I'll just go through it.
Then give the number, let us tag all this matter and hear it.
No, I have not filed.
No, I know. Give the particulars. Mr. Das, Land Counsel for the Vigilance, submits that against the same routine order, 2 more petitions are pending. 2 more or 3 more?
One is immediately.
2 more petitions are pending. He submits that all the matters can be, all these matters can be heard analogously, least the matter. Immediately after the case.
Lord, if any application will be filed, my lord,
The vacation, immediately after vacation.
on 21st.
21st, 22nd, anytime. 23rd. Yes.
But criminal ପୂଜାର ହବନି।
କିଛି ପୂଜାରେ କିଏ କିଛି କରିବେନି ଆଉ।
Item 7.
Otherwise, in that person,
For remand and all. That's all.
the trial,
And where there is good fee, you people go. Yes.
Item 7.
Sir, I'm from Jajpur Court, my lord.
Yes, sir.
My lord, the petition is in custody for 17/2/24, my lord.
I'm sorry.
17/2/24. 17/2/2024, in custody.
Yes.
This is my second jury, my lord. In the first jury, your lordship has directed the petition was withdrawn by DLFL number 28/77. Annexure 2, my lord.
Yes.
Withdrawn, your lordship has directed to renew his prayer before the Lord in court below after submission of charge sheet. My lord, after submission of charge sheet and even after examination of the victim, I have preferred question before the Lord in court below, who equally also rejected it.
Where is the statement of the victim?
Victim statement, my lord, your
He is already in examined.
my lord, pardon, my lord.
The victim is already in examined.
Yes, my lord. He examined.
Where is that deposition? Where is that deposition?
He has examined the victim, PW2. Annexure 9, my lord. Annexure 9.
Annexure?
Annexure 9, my lord. PW2 victim.
Sir, in this petition only, till annexure 4 is there.
You are also not giving copy to the state.
And you have also not given copy to the state council.
The position, madam.
Yes, my lord, I am giving you.
CD requirement is
My lord will go the evidence of the victim.
Yes, call for CD. Let us see.
Para 7, my lord, lordship will go.
Do you have any instructing counsel here?
My lord,
Any counsel appearing for you here and physically?
for informant appearing.
No, I am. You have to give the copy of the petition to the state council. He doesn't have the copy. And I am calling for the CD and let us see. Okay, call for CD.
My lord, my lord.
Yes. Next.
Item 8.
The lordship, the petitioner is in custody since 24/5/2023, my lord.
24/5.
Yes, my lord. 2023.
Yes. 2024. 24/5/2024.
23.
23. Okay. Yes.
And the alleged offences are under section 20B to C 25.
What is the recovery?
257 kg of ganja, my lord.
257.
My lord, 21 years old and helper of the vehicle, my lord. It was not in his exclusive possession, my lord. And no criminal incident, my lord.
That's right, but what to do? What is the stage of the Huh? Okay, let the CD come and status of the Mr. Rahul submits that he has not received the CD of the CD and you want to ascertain the status of the trial. Please the matter afterwards. Yes.
Item 9.
Obliged to please.
Custody since 12/23.
Yes, sir.
Custody since 25/12/23.
25/12/23.
Yes, ma'am.
Yes.
160 with 376 along with other offences, my lord. Lordship turn to page 14, my lord.
Yes.
The 164 statement as at annexure 2.
Yes.
Page 15, my lord.
Read it.
ମୁଁ ଆଜି 26
relevant part. গত নভেম্বর মাসে
on 15/8/23 FIR was lodged. Both are major, my lord. And FIR was lodged by the victim Hostel, my lord. Annexure 1, page 8.
What is the age of victim?
35. And present year 45.
Yes, 164.
In the FIR lodged by the
ମୋର ମା ଘରକୁ ଯାଉଥିଲି ବର୍ଷା ହେବାରୁ ମୁଁ ସେଠି ରହିଲି ଇନସିକେସନ ଇନ୍ସପେକ୍ସନ ସେଠାକୁ ବର୍ଷାରୁ ହେବାକୁ ଆସିଲା ତାପରେ ବିସିକେସନ ପ୍ରଧାନ ବୋଲି ଗଲାରେ ଗଲା ମୁଁ ଏବଂ ଓଡ଼ିଶା ଘରେ ଶୋଇଲି ବିସିକେସନ ହଠାତ୍ ଆସି ମୋ ସହିତ ଖରାପ କାମ କଲା ମତେ ଡରେଇକି ମୋ ତଣ୍ଟି ଧରି ଖରାପ କାମ କଲା ବିସିକେସନ ସାଙ୍ଗେ ସାଙ୍ଗେ ଆଉ ମଧ୍ୟ ଜଣେ ଥିଲା ତା ନାଁ ମୁଁ ଜାଣିନି ବୁଢୀ ମା କୁ ମଧ୍ୟ ଧମକ ଦେଲା କହିଲା ତୁ ପାର୍ଟି ମାରିଦେବି ମୁଁ ରାଜ୍ୟରେ ମୋ ଜନ୍ମ ଘରକୁ ଜନ୍ମ ଜାଗାକୁ ଯାଇ ଦେଖିଲି ତାପରେ ମତେ ବଦନାମ କଲା ମୁଁ ଥାନାରେ ଏଫଆଇଆର ଦେଲି and witness is there so many words
This is there is no university where
FIR was to one story assistant developed within 164 we stated another man Borsa in 161 FIR there is story different I have annexed
informant himself. Read the FIR then. What does he say?
ପ୍ରାୟ 5 ବର୍ଷ ହେବ ମରିଯିବା ପରେ ମୋର ସ୍ୱାମୀ ପ୍ରାୟ 5 ବର୍ଷ ହେବ ମରିଯିବା ପରେ ସେ ମୋର ବାପାଙ୍କ ଘର ଅନ୍ଧାର ପଙ୍ଗାରେ ରୁହେ ମଝିରେ ମଝିରେ ସେ ମୋର ୱାନ ସୁଗାର ଥିବା ଘରକୁ ବୁଲିବାକୁ ଆସେ ମୁଁ ଗତ 5 ତାରିଖ ଦିନ ପୁଙ୍ଗେଥର ଆସି ମୋର ଦିଅର ନନ୍ଦଶ୍ରୀ ଗ୍ରାମର ଶ୍ରବଣ କୁମାର ପ୍ରଧାନ ଘରେ ରହିଥିଲି 5/8/23 ତାରିଖ ଦିନ ମୋର ଦିଅର ସହ ପାଟିତୁଣ୍ଡ ହେବାରୁ ମୁଁ ତାଙ୍କ ଘରୁ ତା 7/23 ତାରିଖ ଉପର ବେଳା ପଳାଇ ଯାଇ ମୋର ସମ୍ପର୍କୀୟ ମା ହେବା ତରଣୀ ସାହୁ ଯିଏ ମା ପାଖରେ ଗୋଟେ ଏକୁଟିଆ ଘର କରି ରହୁଛି ତା ଘରକୁ ଯାଇ ସେ ଏକୁଟିଆ ରହୁଛି ଗତ 7/8/23 ତାରିଖ ଅପରାହ୍ନ ସେ ସେଇ ପାଖରେ ଛତୁ ଖୋଜୁଥିବା ବେଳେ ସୁହେଲି ଗ୍ରାମର ବିଶିକେଶନ ପ୍ରଧାନ ପିତା ସ୍ୱୟଂସ ମତେ ଦେଖା ହୋଇ କଣ କରୁଛୁ ବୋଲି ପଚାରୁ ସେ ଛତୁ ଖୋଜୁଛି ବୋଲି କହିଥିଲି ଗତ 8/8 ତାରିଖ ରାତି 8ଟା ବେଳେ ସେ ସେଇ ମାଙ୍କ ଏକୁଟିଆ ଘର ରଖିବା ବେଳେ ସୁହେଲି ଗ୍ରାମର ସେଇ ବିଶିକେଶନ ପ୍ରଧାନ ସେଠାରେ ପହଞ୍ଚି ମୋ ସହିତ ବଳପୂର୍ବକ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା ସେ ମତେ ମୋର ମା ତରିଣୀ ସାହୁକୁ ଧମକେଇବାରୁ ଆମେ ଦୁହେଁ ଚୁପ ରହିଲୁ more than 1 year from August 2023 eyewitness
ମୋ ବଡ ନସର ଝିଅ ଲାଗିବ ମୋ ସେ ଝିଅ ଯାହା ନାମ ମୁଁ ଜାଣିନି ମୋ ଘରେ ଥିଲା ମୋ ବର୍ଷା ହେବାକୁ ଥିଲା 2 ଜଣ ଆସିଲେ ଏବଂ ମୋ ପାଖେ ବସିଲେ ସେ ପିଲା ସେ ଝିଅକୁ ରେପ୍ କଲା ତାର କପଡା ଚିରିଦେଲା ଏହା ଦେଖି ମୁଁ କହିଲି
too much may interim
So the ground should be there instead of application.
custody is not by of right. It is more than 1 year. And therefore, variation in all steps.
In this kind of situation, there is a chance of acquittal. So 3 months are better that you permanently. Yes, next.
Madam, here because of the deteriorated health condition of the present petitioner, he is constrained to file an interim bail application.
What is that?
I have filed that is Madam C. Kindly see. It starts from page 5 because of the
Page 5 of
interim application.
that is 1 to 8.
And then Madam C, because the petitioner is in custody for about last 1 year because of the allegation.
What are the offenses?
So 302, madam. Village dispute and there are is there. What it be around 16%.
What is the problem?
No. Renal problem and severe bleeding was there along with pain. You are taken to fast to the concerned district headquarters hospital after 2-3 days of preliminary treatment, and because of the fact that no treatment was given. The condition is definitely. And we see page 7. He was also referred to the Pinsar Bull Hospital. There also page 7 was last part. After some clear treatment, he was advised to go for this to put in nephrology department. Instead of this, he was brought to the hospital, brought to the jail. Now he is jail.
Medical paper have to verify it.
Yes.
Let him verify. I am saying. Tomorrow, how can they verify? Tomorrow will happen our own court. Court is only for happening.
My humble submission, because these are not documents to be verified from a remote place. The concern.
I don't know if we can do it. I will take it.
He has to say.
Can you do it tomorrow?
Let my friend plan. Let my friend plan.
Give it tomorrow, but very doubtful. Tomorrow is very much doubtful. Give it tomorrow for verification. And you don't have a good case on merits.
No, no, I mean, that matter you consider.
That's for sure. That is the reason this.
He has been referred to Vimsa.
Let him verify. I will dismiss the main bail plea,
Yes,
but
ma'am.
I will give 1 month if, you know.
Local man, no chance of being aware. This is admitted.
Anyway, let him verify. I'm not sure whether you can do it or not. Why can't we keep it in the first day of vacation?
The whole problem
Tomorrow will be, see,
is suffering because the suffering and he has not been taken and the no facilities there and he had permission deputy. That's why I have answered.
After vacation as well,
he will die in the no. Let us see how he died. Let us see. When was the first report?
Now we see 16 September. Now we see page 6. Page sorry, page 5. Page 5 left side top we see. On 16 September 2024, around 2:21 p.m. he was taken to the district headquarters hospital. Yes, that to married see page 7.
16:9.
On 19th September, he was taken to Hon'Ble hospital, which is about.
And you have all the documents 16 and 17:9.
No, because of the fact that I am in custody. But with the
That's right. 16 and 17. Nothing has happened. 16, 1 month. Now.
No, not wait for another 19 minus 19.
But anyway, you see, try if possible. If anything can have happened, ever. Yes.
Madam, it will be better to take instruction from the jail authorities.
Whatever you try, if it happens, it's all right.
And jail authorities also take care of that.
Subject to report. Yes.
May I please?
Yes.
Petitioner is nearly about 60 years old, mother-in-law.
Mother-in-law. Well, yes.
And she's inside custody since 8/11/2023.
Yes. Charge sheeted.
Charge sheet already filed, my lord.
302.
My lord?
your lordship is going to another go to
Bina is sister.
And this mother-in-law and this Binane. Binane is the sister-in-law of this. And this lady is the mother-in-law. So we have been paid the main law. And the disposal of petitioner Binane. And there is the eyewitness is there. You are directed to come approach after the examination of
The same order will be there. Same order. Same order. Same order. Same order. ये मदर ये मदर-in-law ठीक है सब ठीक है
That item 4 notes of passport take instruction notes. Words have obtained instruction notes. Specifically, it is stated that he can avail the order benefits of the order if the amount is bank guarantees to the tune of 25 lakhs. It's not possible on his part to. That is what my senior is suggesting. Let's
25 lakhs bank guarantee and rest property security. Rest means how much? 1 crore.
No, rest 25 lakhs. Lordship suggested for
50, 25 lakhs property security. And these are for 2 months only. 2 months. Are you for 2 months?
He was praying for 3 months if it can be.
Let it be 3 months. He's spending so much and for travel, you know what is the cost nowadays. He'll spend at least 5-6 lakhs to go there. 3 months. So 3 months, 3 months and yes.
My lordship.
Yes.
My lordship. There my offense under 13(2), 13(1) CD and 409 PC Act and 409 and 34 IPC malad.
Sorry?
409 and 34 IPC. 13(1) to 13(2), 13(1) PC Act and 409 and 34 IPC. Yes, sir. Present petitioner is retired video filer. He is in custody 23/8/23 more than 1 year.
8/23.
Yes, sir.
Yes.
earlier coming lawsuit direct,
What are the allegations?
allegation misappropriated the money of, there is 5 cases, my lord.
Against you 5 cases.
5 cases, my lord.
No, total case
As it
registered
was
7 cases.
7 cases.
In 7 cases, in 1 case he has been convicted and filed appeal before this honorable court. In 1 case he has been granted bail. Before your lordship, today 5 cases have been listed. Your lordship may kind of glance. PLFBL number 2692, 1967.
What was he? What was he?
He was VTO Narayanapatna block. Your lordship may kind of glance to the letter number 774 bar 8 I have submitted.
Okay.
Bar. Your lordship.
Earlier occasion, lordship directed.
Your lordship may kind of glance to the last para of the appraisal report. Your lordship will be satisfied.
Appraisal report. When there?
Appraisal report, superintendent of police vigilance for last paragraph.
Yes.
Your lordship got.
What is that?
Last para is Ramesh Chandra Sahu being an OS. Your lordship got.
No,
Appraisal report.
no, I'm not getting it.
Bar.
Bara.
Bar address.
Bara.
সেটা ଦେଖିଥିଲେ already এই কেসে earlier occasion lawsuit directed to state council on a condition that ତାଙ୍କୁ ଠିକ presence
She will be satisfied. Only after 9 years he was apprehended.
After 9 years you have started.
I used to be a case granted anticipated.
Where were you?
Yes.
Oh, he came and got the anticipated bail.
No.
Came and got anticipated.
Service was over 3 years more. He did not apply for a leave. He went away. And
1 year costed.
He so much money he has to spend.
37.
Therefore, he went. 9 years he spent money and came back.
37 lakhs. Paper Barla Nirudishta. Collector Barla. Nirudishta. Thereafter, Jammu Kashmir
earlier occasion ଆପଣ you lawsuit directed to state council କଣ condition ଦେବି?
What are the offenses, by the way?
409.
Yes. 1 year.
It is all right, but how many people?
It is fit and proper. I have no objection. Here, if a lordship fixes.
What is the amount involved?
Amount 37 lakhs.
23 lakhs.
23 lakhs.
37.
Okay, 23 lakhs. You deposit 23 lakhs.
No, already
You have a lot of money. You deposit 20 lakhs.
ପଇସା ନାହିଁ ବର୍ଷେ ବର୍ଷେ ଉପରେ ରହିଲାଣି
Taken 9 years to search you out.
Yes.
And 1 year only.
23 ଲକ୍ଷ ଟଙ୍କା dispute already no
You seek instruction, what is the amount you can deposit? A respectful amount. I'm not saying that it's a kind of recovery, but
total amount
you should face it.
total amount 1 lakh. Yes, bank
Bank guarantee.
Yes. Bank 20 lakh ନା କମ
You seek instruction, come.
ବର୍ଷେ ରହିଗଲାଣି
Seek instruction, come. How much you have earned a lot of money. 13 cases you have. 7 cases.
ନା ଆଜି 5ଟା କେସ୍ ଅଛି କିଛି ନା 5ଟାରେ ବିଲ୍ ପାଇଁ ଅଛି ବିଲ୍ ଅଛି 5 lakhs
Different amount.
ଏଇଟା ଟୋଟାଲ 23 lakh 5 lakh
1 lakh in all one.
yes 5 lakh
Yes.
ନା ଆପଣ ଯେମିତି
Bank guarantee, same thing, bank guarantee or
And property security. Bank guarantee is what?
bank guarantee. See, bank guarantee is also has to, you know.
ସେ ରଖିଛି ଟଙ୍କା ରଖିଛନ୍ତି
ମୁଁ ତ ପାଇନି bank guarantee and property security.
yes
ଆଉ ପ୍ରପର୍ଟି ସିକ୍ୟୁରିଟି ଦେବେ ତାଙ୍କ ନିଜ ଘର ଲୋକ ଦେବେ ସେ ଫେକ୍ ମାନେ ସବୁ ଆସିକି
ଭାଇ ଅଛି
See, I'll tell you, whatever property security will give, it is his property. Benami property will give, no, his relative.
82, 83 already somebody more.
Okay, 1 lakh, and it is on your statement. I am not asking you.
Bond security.
And property security. Property security of what amount?
Indemnity bond बाकी तक करो. Indemnity bond.
For accused gives an indemnity bond. What is the meaning of indemnity bond for an accused? And
that all the
it is only the idea is only that you have to give a pinch of he should have full the pinch of it. That's the idea. It's not a recovery proceeding. And in all the cases he is entitled to bail. In earlier these offences immediately they used to get the bail.
That's it that all the cases are in the trial stage. So my prayer that's it that he should appear in person in all the
You give in writing whatever conditions.
condition. He should appear in each cases in all.
Yes, he will not seek adjournment. He will not seek adjournment.
That's it, some cases
Not seek adjournment.
in person.
Bank guarantee and 4 lakhs in every case. 4 lakh rupees property security. Worth 4 lakhs rupees.
And should appear before
Yes.
in the court on each and every date of posting of all the cases.
Yes. And we will not seek adjournment.
Indemnity bond 4 lakhs ଏବେ ତ ଦେଇପାରିବ ନା ଭିତରେ ଅଛି
ବାହାରିଲା ପରେ ଦେବେ
ହଁ
ବାହାରିଲା ପରେ within 1 month after release.
He
Yes.
should appear in each cases and also before the SP.
All the
Appear before the SP vigilance CORAM. Once in a week or 15 days.
He'll appear in once in a
Not only
once in a month. Once in a month.
twice in a month.
Twice in a month. Every 15 days. Every 15 days. He's correct. See, otherwise you will run away and they'll keep on searching you.
And the conditions if it will be.
You are saying so many conditions, therefore I'm saying, please, give in writing so that I interpret.
You seems to say that a condition violation of any condition.
Oh, that is there.
I pray that only.
Yes, that is. Yes.
All the 5
All the 5 cases separate. Okay.
and 3 copies of this order I will have to send.
And Mr. Das has vehemently opposed, and because of the past conduct of the petitioner, he says that even if the petitioner is allowed on bail, stringent conditions will be imposed. Okay? Yes.
Item 14.
15 my lord, permitted to withdraw.
Withdraw. Thank you, madam.
See.
Item 15, item 15, my lord.
The allegation of my lord 417, 419, 376, 3 that all the 4 can continue, please have it.
We have to be a case. Regard will head to the period of custody for more than 1 year.
Pardon, my lord.
Yes,
In
my
this case,
allegation of 417, 419, and my lord 376, 3 IPC, and section 6 of
Notice was issued.
Notice was issued, my lord.
It was sought to the victim on 7/4/2024.
my
7/4/2000. And
I may pardon, my lords. Am I audible, my lords?
Notice was issued last date of hearing. Just see. Press notice was issued.
Either 18 or unserved notice returned.
Press notice was issued on 20/8/2024. But wait for that. Wait for the service.
we start
On 28/8/2024, fresh notices were issued to opposite party number 2, public informant. The service is still awaited. Lease the matter after it. Yes.
my lord, my learned senior is something that nothing is available.
Last on 28th, the fresh notice was issued. So we have to wait for that matter. Easily. Yes.
And where may be fixed, my lord?
16 date will give. Yes.
Item 16, am I audible, my lords?
Yes, yes.
My lords. My lords, in this case, my lords, petitioner is in custody since 25/8/2022, my lords. That is 2 years, 2 months inside custody, my lords. And in the case, charge sheet has been submitted.
Custody since?
Charge sheet submitted 302 IPC, my lords. Custody date, my lords, 25/8/2022.
My lord,
2020,
25/8/2022.
22. Okay.
2022 ଆଜ୍ଞା। My lord,
Out of 7 witnesses,
out of 18 witnesses,
7 witnesses exam.
but yes, I have provided a lordship with the deposition copy also to my friend appearing for the state millards. Deposition copies are the flag M, my lord.
Yes, I got it. Yes.
My lord.
Have you seen it?
Out of,
Yes.
my lord, PW5, my lord, this is the informant.
Informant.
My lord.
What does it say?
He is post occurrence witness, my lord, having no direct knowledge, my lords. And the case is based on the seizure of the weapon of offense, my lords. And the seizure witness, my lord, PW2 and 3, my lords. They have resiled, my lords. They have not supported the seizure and their statement before the police, my lords.
Para 2, your lordship, PW5.
Para 2, I'm reading you. Certain that Ravindra has assaulted.
Ravindra has assaulted.
He is not seen.
No one has seen.
Nobody has seen. My lord,
For a silly reason, that with intoxication he has assaulted by means of a wooden plank. Single blow is there. Wooden plank, and that wooden plank.
Maybe son-in-law.
No, neighbor.
No, neighbor, okay.
And cerebral injury, PM report is cerebral injury. And my lord, the trial is going on, and informant has not been examined. No one has seen the occurrence of all are post-occurrence witnesses.
What is the evidence then?
On evidence that PM is cerebral injury, and that only the leading discovery that would have
he died and everything is all right. But how will you link this accused?
Well, only on that reason that post-occurrence witnesses stated that he was assaulted because no one is there. Only that patent petitioner and the deceased. And the investigation reveals that there is some silly mistake. He has intoxication. He has assaulted him. The deceased by means of it that we don't find.
What is the evidence to that effect?
Only one
evidence.
Leading to discovery. There is no any other evidence, man. All are post-witness occurrence.
Nobody has seen.
Nobody has seen.
There is no eyewitness to this.
And also,
what is recovery?
Wooden plank was recovered from the present petition.
Next to the seizure.
My lords, witness to seizure PW2 and 3, my lords. They have not supported, my lord. They said they don't know anything. Lordship kindly see.
Ganesh and Singarai Murmu.
PW2 and 3, my lords.
What is their then?
No, PW1.
Not 1. PW2 and 3, my lords.
They were
not supported. There are 27 goes.
27 goes. There is no other evidence.
What is there? I will enlarge. Okay, right. Petitioner is accused in so case. Allegation against the petitioner in so case. In the present case, out of 18 witnesses, 7 witnesses have been examined. PW2 and 3 are the seizure witnesses. Whereas PW7, PW5 is informant of the present case. There is no eyewitness to the occurrence. The petitioner is implicated on the basis of his disclosure statement, leading to recovery of the weapon of offense, that is the wooden plank. The seizure of the wooden plank is alleged to have been witnessed by PW2 and 3. The state witnesses have not supported the prosecution. Therefore, they were declared hostile and subject to extensive cross-examination by the prosecutor. However, nothing could be elucidated from their evidence against the present petitioner. PW5, who is the informant, has stated as under para 2. PW5, page 20, para 2. PW5, this witness has also not seen the occurrence. He has only stated that he has ascertained that the present petitioner has assaulted his father-in-law. Likewise, other witnesses have also stated before police that although they have not seen the petitioner assaulting the deceased, however, they came to know from their sources, that the present petitioner has assaulted the deceased. In the absence of any direct evidence against the petitioner and direct evidence against the petitioner, only solely on the basis of the disclosure statement, the petitioner has been arrested. Petitioner has been arrested. The petitioner is in custody for more than 2 years. That is from 25/8/2022. Since the vital witnesses to the probe have already been examined, and none of them have examined. Out of them, senior witnesses have not supported the prosecution, and the other witnesses, those who have been examined, have only stated that they came to know regarding the involvement of the present petitioner in the alleged crime. I am of the considered view that the petitioner is entitled to bail, entitled to bail. Bail is granted, and he shall appear before the court without bail, and he will not seek unnecessary adjournment. He should be. Okay, granted. Yes, sir, granted. Yes.
70 oral time declaration oral time declaration is also not there. If oral time declaration is there, then there might have a case. Oral time
nothing. Absolutely nothing. Yes.
70.
See, problem is if you don't give bail to these kind of people, they're bound to be acquitted. Then you feel guilty.
They are in no such evidence.
See, then you feel guilty.
Yes. Is there, so court will also be rejected.
Yes.
70.
Yes, 17 non-APS. In the last date of all hearing also non-APS. What is the offense?
376, man. 376 to N 417.
On 2/9/2024, the matter was taken up. Non-APL. Non-APL for the petitioner. Is for the petitioner even today. Therefore, the present bail application is rejected, reserving the right of the petitioner to renew the bail plea trial court. If such bail plea is removed, same shall be considered on the basis of the material which has come on record. With this observation, petitioner is disposed of. Yes.
18.
Withdraw. Yes.
19.
Yes. This is last occasion your lordship had asked me to.
You are in congratulations.
This is for qualification.
So you got the antecedent which I had also disclosed before while moving the bill application. Your lordship said that I am not. Your
lordship court has rejected.
On that.
How will you get over 37?
37, in view of that decision, your lordship also.
Which one?
That Rajasthan High Court decision. For a constitutional court, my lord. And here,
Nur Mohammed case, my lord, Supreme Court has said that 21 may also come on NDPS and
nothing has been seized from his conscious possession. It was kept on the roadside. The ganja was kept in the roadside, malad. And this man was compelled to confess, and thereafter the jury bags were seized. That is how this man has been implicated. And the part you are reading,
which part of this?
Paragraph 34-35.
30?
34-35.
Have you seen it?
No.
Copy nahi. Bimal Rajput, state of Rajasthan. Citation of the live law bar.
It's otherwise. The last sentence it says. No. Last sentence it says that with so and so DPS Act, but this court cannot choose an interpretation which will render the provisions contained in under section 36 capital of NDPS Act redundant and dubious. And 37 also.
Here is a case where the allegation
that were meant to be applicable to the court. No, 38, para 38. Para 38. Where is your name? Do you have a copy? What are you have to? Para 38 rather helps you. Para 38 says in the judgment, in view of the aforementioned discussion, of the court view that the restriction contained in section 37 of NDPS Act were meant to be applicable to the courts other than the constitutional court, and in view of the provisions contained under section 36 capital A 3 of NDPS Act, those restrictions do not apply to the constitutional court. That's what the view of the I will check. See, I want to write a judgment on this so that it will help. Give assistance. Paragraph 35. And give this parameter judgment by the Supreme Court.
That also Tufan Singh case is there relying on
Tufan Singh will not.
That decision, your lordship knows. You have to compel. They cannot compel the persons to give a confessional statement, my lord. And then
what I'm saying is just get some judgment where it says that to improvise this version is correct. The constitutional court is not bound by the restriction under the statute. Statutory restriction under section 37 will not restrict the power of constitutional power of the court. But exercising power under 439. I'm not exercising the power under constitutional court. So this view, I don't know whether it is correct view or not. Can you get some judgment?
Your lordship said this is the decision.
Because I am exercising 439. I am not exercising constitutional
439. In a specified case, but here is a case your lordship has already granted bail. The only thing is that there is a previous case which is of course not similar, exactly similar. But that was a case where some plantations both were there in a government land. And the honorable court, after considering that this is the honorable court has granted him bail.
That's you are entitled to bail, therefore I have bail. The problem is you are involved in some other case, one of the condition is hurting you. So I have to dilute that condition.
Yes, my lord.
Dilute that condition. If for diluting that condition, 37. So then I have to write a judgment to say that 37 will not operate.
He's a man of 60 years, my lord.
Maybe.
And your lordship sees, my lord, page 9, if your lordship will kindly refer to 9, my lord. How it has been seen?
This is Allahabad view and this is Rajasthan
view.
No. This is Allahabad view.
I think that is
This is Allahabad.
Allahabad.
Yes.
But I need to
Was rejected. So case cause of action, he may be reduced payment. If the court has to not court has.
I want to.
Implicated in this case, my lord.
I want to get an order in this matter. I want to assist the court.
I will try to assist.
I'll put it. 20 seconds, please. No, I'll use this occasion to write. It will help others also. You are entered like grant, that's not a big problem. I have already given.
ବୁଢା ଲୋକଟା ତ ସେଥିପାଇଁ I was worried about. 60 ବର୍ଷ ବୁଢା ଲୋକଟା he has been implicated this way. ସେ ଗୋଟେ ରାସ୍ତାରେ ଥୁଆ ହେଇଥିଲା ତାକୁ ଜବରଦସ୍ତ କଲେ ତୁ ଏଇଟା କନଫିଉଜ କର ଏଇଟା ତୋର.
See, if I dispute it up, I can't write an order, judgment.
Therefore, let us use it. ଗୋଟେ କେସ୍ ରେ
Get that judgment. And reopening date. Reopening date, 22nd. Come with the written note.
2044.
Come with the written note.
Item 20. Well, I'll take a note after that.
After it. And you will cut hold of some judgment which says that if a constitutional court exercising the power under the procedure, then the power, constitutional power doesn't cease. If a constitutional court exercising a procedural power, that doesn't mean that the constitutional power of that court ceases while exercising discretion. Because Code 39 is a discretion. So discretion, the constitutional discretion also can be, employed for the purpose. So that in many matters it can be used.
It has been dealt in by our court.
That judgment for that. Right.
8067.
Give a write-up. Give a write-up. Yes.
The recent judgment of Supreme Court is M. Balaji.
M. Balaji will also help.
Yes. That is
Just see, that is how you read the entire judgment.
That decision set refer.
I expect a write-up, from
21.
May I please, Lord?
Yes.
But should may kindly remember that case, my lord, where there have been a relationship, continuous money transaction was there between the informant and the present petitioner. On the last occasion,
you had taken some money. Yes. I told you to give some money. How much?
बहुत कष्ट डिमांड ड्राफ्ट कर जाते हैं आओ पैसा कष्ट अच्छा है तो तापर लक्षण कौन करेगा बहुत कष्ट 50 डिमांड कर जाते
Okay, first give it. Okay. Hold it. Let us see on merit. See if you don't see. Yes. Let us see on the merit. Well, see, you have been keeping relationship with him for such a long time, and then you say, what is your age?
28 years.
You are 28 years. What is your age?
My age is also same.
For how many years?
Both are classmates. Both are classmates.
Higher second grade. May I just kind attention, your lordships.
She is working as a staff nurse. To both are classmates.
Relationship. Yes, no doubt about it. Yes.
No relationship. Your lordship.
Then why have you kept relationship for such a long time?
Your lordship can see the
How many years?
that is not mentioned.
4 years, my lord.
4 years you have been staying
From 19 to 2023.
No your lordship.
Yes.
Can you see the
Yes. Read. Yes.
he called me. Thereafter to get physical relationship without my consent. Blackmail me. Taken money from time to time. That was reflected in the FIR.
This is going on since how many years?
2019 to 2023.
Your lordship can see time and again. She was taken the money. Not a single day. 5,000, 10,000, 2,000.
1000 টাকা 1200 টাকা 500 টাকা 800 টাকা কোর্টে গেলে কোর্ট খাইলে কোর্ট বসে
In 2009, FIR you say since 2019 this is going on.
আগে
FIR you filed in 2024.
Last on the day of previous day, he demanded the money. When I did not pay, he was assaulted. And in the meantime, in which place I was working, I was also drove out by the organization. I was working as a staff nurse.
This is a law of FIR.
There was
Wrong.
it is a
कहीं कर what have you recovered? Any nude photograph? Any?
no কিছু লাগে না
No.
Just check it out. Allegation, viral.
ফাইনাল ডক্টর আছে তো পড়ুছি
वायरल कर दीजिए.
ডকুমেন্ট আছে ভাইরাল তো নাই চার্জশিট না ভাইরাল 3761 323 406 ডকুমেন্ট আছে এটা
Yes.
ভাইরাল না নিশ্চয় কোড নাই
164. Read 164.
164 is there
Read 164. Medical evidence.
medical evidence is not there that I have given in that medical report does not support প্রথমত ଅଛି রিলেশনশিপ কথা
प्रथम कोर्ट कलिंगनगर घर रे ही रिलेशनशिप स्टार्ट
mobile ଅଛି 164 কথা so 164 is also there in that
Medical report also there is nothing.
yes
habitual relationship you are also
admit করলে habitual relationship
habitual relationship you are blackmailing me
And to the doctor you have said that he was your childhood friend.
in the FIR that was also admitted I was a childhood friend co-villager
Custody since?
well custody since well 8 2023 well 8 2024
8324.
24
Yes, will you take that money or you take it?
oh my god
Not take.
I will take instruction from the client
Yeah, you keep it and take instruction first day of your opening. I will grant you. First day of friends. You take, let him seek instruction. 50,000 rupees, huh? Yes. Because this is a case appears to be consensual. 2019 to 24. There is a sexual relationship. Medical evidence says nothing. And you have made all kind of allegations. If that was the case, in the first day of the sexual assault, you should have gone to the police station. But you are not a minor.
no that was not done
You have been working, both of you are class fellows.
class
So all these things are there. So that's
the lordship has expressed that how much money he can pay so
I was thinking money, at least whatever money you have taken, some money you will get it back. 50,000 rupees he is paying, take it and
I will take
seek instruction first day. Yes. First day reopening. First day of reopening. Well, okay.
ଝିଅ କେତେ ଫାଇଲ ଧରି ଉଠିଗଲା ସେ ଝିଅ କଣ ଫାଇଲ ପତ୍ର ପୁଳାଏ ଧରିକି ହେଇଛି
Yes.
The lordship last argument is call for schedule, my lord.
See that?
Yes, sir.
Yes.
Open under section 376, 506, 354A.
Yes.
CORAM 12 Boxton. 372, my lord, 19 years old boy.
Okay. Read 164. 164 statement.
Yes, yes.
Read it.
ମୁଁ ତା ସହିତ ପ୍ଲସ୍ ଟୁ କମର୍ସରେ ପଢୁଥିଲି।
Have perused the evidence on record form part of the charge sheet and also seen the photographs which have been seized by the police. Perusal of the photographs seized by the police are not explicit. The petitioner is 19 years of age. It appears from the evidence on record that the petitioner, who is 19 years of age, 1 year senior to the victim, who is 17 years of age, they were in the relationship. তারপর ফারা পেলো এর করলো তাদের it is law affairs, adolescent law affairs gone stone. Adolescent cutting 25 years to adolescent for the age 25 ठीक है, and all the restrictions. Yes.
Okay. 25. Name please proceed. Offense of 302 yard. So history since 16/6/2023, my lord. In the meantime,
16/6/24.
16/6/23. What happened in this case, my lord, this is circumstantial evidence. The jungle, my lord. And as per the charge sheet, my lord, the police
witnesses have been examined.
The material evidence already examined and they turned hostile, my lord.
Yes.
As per the charge sheet, my lord, in course of investigation of the case, all the instruction of the case and have complied sufficient evidence gathered to prove the case, that is statement of the complainant and the other evidence are recorded. Statement of the eyewitness, namely Prakasha Jama and Vishwanath alias Railway Sinku, they have been examined and turned hostile, that is a Schedule 11 and 12. For that even, and the complainant also turned hostile. Means that I have not about
Place it on record then. Place it on record.
Yes, yeah.
There are two options because all these evidences are recorded into July and May 24.
October.
Your bill application was rejected on March 2024.
Yes.
And we have to go to the trial court and tell all these things.
Again, I will go because
that is the principle. See, evidence has come on record. You have to tell that court. March the evidence was the bill application was rejected. 202 case. Evidence has not come. Don't tell that court. That's right, but see, the trial court has to do all these things. We will not. You file, I will examine everything. What is there or what is not there?
Because of hostile for that reason,
hostile doesn't mean that the evidence will be thrown out. No, we will see. Yes.
Within 15
days, we let the trial court decide the application. Right. The petitioner is agreed by the order dated 20th March 2024, where it plea had been rejected. Subsequent thereto, 13 witnesses have been examined. And counsel for the petitioner submits that the vital witness to the prosecutions have turned hostile, including the complaint. And in view of the changes, should bring to the trial court, and the trial court to dispose of the bail plea to be moved within 15 days. On the basis of within 15 days of moving the application, on the basis of the material of the yes.
26.
26 May, your lordship. Your lordship, the 26 allegation against 498, 305, 304B, 306, 34, and 4 of dowry provision.
Yes.
Earlier, and since there is two bailable, one is for mother-in-law, one is for husband minor. No, I'm for mother-in-law. So husband
Joint Jana. Okay.
Joint Jana. She is the mother-in-law. Well, if your lordship sees the inquest report, my lord. Earlier, your lordship on the last occasion, lordship directly to go through the inquest report. In inquest report, it is clearly written that, my lord.
Yes. Charge has been filed?
But no charge is framed. Charge not a
When charge is filed?
Charge is 5/2/2024, and the petitioner since 19/12/2020.
19/12. 23.
Yes. My lord, may I place the inquest report, the relevant portion? My lord, I visited the spot in pressure of executive magistrate on SODFC.
That sheet is 302.
That's
No, no.
304B, 306, and 498.
Yes.
And then pressure A and the last C, the SOD DFC.
What do you want to tell me?
That is bail, my lord. Since
Where I know, from where, what do you want to say?
and one ligature mark was found on neck itself. No, it's anti-mortem. No such injured mark except the ligature mark, my lord. Since just because the social stigma, she committed suicide because she is issueless since last 3 years. Since her marriage was on before 3 years, she is issueless, my lord. And if your lordship,
Out of frustration, she has committed the.
and the lordship see the statement of executive magistrate. She said that ମୃତ ସ୍ତ୍ରୀ ଲୋକର ବେକରେ କଳା ଦାଗ ଥିଲା ଏବଂ ଶରୀରରେ କୌଣସି କ୍ଷତ ଚିହ୍ନ ମୁଁ କିମ୍ବା ପୋଲିସ
Yes, I am reading the statement of that executive magistrate who has conducted the inquest matter. Aji,
Something is prompting you. Yes.
ଆଜି 8/12/23 ରେଖ ଦେଇଥିବା ଆଡ୍ରେସ ଅନୁସାରେ ଘଟଣାସ୍ଥଳରେ ଯାଇ ପୋଲିସକୁ ଶବକୁ ପଞ୍ଚନାମା କରିବା ବେଳେ ଦେଖିଲି ଯେ ମୃତ ମହିଳାଙ୍କ ବେକରେ ଦୌଡ଼ି ନଥିଲା ତାଙ୍କ ବେକରେ ଏବଂ ତା ନିଜ ଘରେ ରୋଷେଇ ଘରେ ମରି ପଡ଼ିଥିଲେ। ମୃତ ସ୍ତ୍ରୀ ଲୋକର ବେକରେ କଳା ଦାଗ ଥିଲା ଏବଂ ଶରୀରରେ କୌଣସି କ୍ଷତ ଚିହ୍ନ କିମ୍ବା ପୋଲିସ
From the
from the room to the
that is the question.
to the kitchen. There is also no in the neck.
See, they stated that with the
I think the other day you argued this matter. I was not inclined, therefore it's not yet.
even also not influenced, but rather directed me to go through the inquest report properly, ma'am. You are not.
Is there any opposition for that? Yes, there is opposition also. Yes. Yes, madam. You explain how the dead body has come from the room kitchen.
No,
You were there.
before the informant and any other person is there, the mother-in-law and the husband informed the informant that your daughter is not opening the door. See, they inform.
Where is that?
That is the statement was informant, my lord. That is ମୋର ନାମ ରମେଶ ଚନ୍ଦ୍ର ପରିଡ଼ା, ପିତା that is ଏଇ କଥାକୁ ନେଇ ଆମେ ବହୁତ ଆଗରୁ ମାନେ ତାଙ୍କ ଭିତରେ ପାଟିତୁଣ୍ଡ ହଉଥିଲା। ଏଇ କଥାକୁ ନେଇ ଆମେ ବହୁତ ଥର ତାଙ୍କ ଘରେ ସମାଧାନ କରିଥିଲୁ। ସେତେବେଳେ ଜ୍ୱାଇଁ ମାନି ଯାଇଛି, ପରେ ତାର କଥାରେ ପଡି ମୋର ଝିଅକୁ ସବୁବେଳେ ଟଙ୍କା ପଇସା ମାଗି ଝଗଡା କରେ। ସେଇଦିନର କଥା ହେଲା my lord, ज्वाଇଁ କାମକୁ କଲେ ତା ମା ମୋର ଝିଅକୁ ଅଶାନ୍ତି ରଖି ତାକୁ ସାମାନ୍ୟ ଖାଇବା ପିଇବା ଦିଏ ନାହିଁ। ଆଜି ରାତି 8 ଘଣ୍ଟା ବେଳେ ମୋର ଜ୍ୱାଇଁ ମତେ ଫୋନ କରି କହିଲେ ଯେ ତମ ଝିଅ କବାଟ ବନ୍ଦ କରି ଘରେ ଅଛି, କବାଟ ଖୋଲୁ ନାହିଁ, ଜଲ୍ଦି ଆସ।
How the door was opened? How the door was opened?
They forcibly broke the door.
Where is that? That is what I am asking you. Tell me.
There. एक
Rope was not there.
That was the whole thing.
with that piece of
You have anything on record to show that you opened the door and brought her from the bedroom to kitchen?
she committed suicide where she did not commit the point that she did not commit suicide by that piece of cloth, my lord. It is not there. Nobody stated that because since the informant, no eyewitness were there, my lord.
Eyewitness in this case, what are you? Anything to find out, anything to
All is totally suspicious.
that is the whole difficulty.
Because the executive magistrate who has conducted inquest report, she has stated that there is no rope. They are also not giving satisfactory answer how she was died.
And she also stated there is no such injury mark.
Simply again, let her be there because yes, see, no. See, 19, 12, 23, not even 1 year, not even 1 year.
Your lordship,
No more director, no more doctor.
the mother-in-law, the let the husband of
Mother-in-law and husband is the good too. And you show me, what can I help you? How can I help you?
since in medical report, a postmortem report, the asphyxia due to hanging, my lord.
And that I understand, therefore 304, I am just asking you 304B is also there.
304B is there.
And when she committed suicide, that both the even if both the husband and the mother were not present at home, when they
Show me that is what I am asking, madam. You show you were not there. Then I grant the straight away.
where is this stated? So for any of the statement of
Madam, you are not even fully prepared. That way also I say that you prepare. Give me some evidence so that I can grant you the some evidence that you are there or something like that. I have to write it. I have to justify the order also. You prepare it. You prepare it. Okay.
Both are present. Both are present.
That's the problem. I have to see it. And you are not filed. And then file the charge sheet, copy of charge sheet. That's not going to be six an adjournment to file the copy of charge sheet. Let him do so within 1 week. Release the matter. Right? Yes. Yes. 27. Non-APS for the in the interest of justice adjourned December.
28.
On behalf of Mr. Rai Mallet, I may be permitted to close the matter. That offense under section 307 and section 3 and 4 Explosive Substances Act.
Yes.
And the present petitioners may surrender before the Illinois Trial Court on 24/2024.
24, 24. Okay.
24.
Yes.
And my lord, charge sheet my lord has been filed
on
lordship that is my lord 1/8/2024.
1/8/24.
Yeah.
Yes.
Here is the case, your lordship kindly turn to my lord page 13 of the FIR. My lord, allegations my lord against it during the zero night celebration, the present petitioner along with others, my lord, threw bomb in the bari side of the informant's house. Any injury like it.
Where have you got the bomb?
My lord, that is my lord from the FIR page 13.
No, from
My lord, in this case, my lord, series of cases, my lord, against the petitioner, my lord.
Okay.
21 numbers
using bomb, explosive,
and Iowa seized ball, jeweled, iron pins, small chips, small glass pieces, small documents.
Right on.
My lord, intention is there, my lord.
Right on. By the order dated 17/5/2024, the bail plea of the petitioner was rejected. Hence, the present petition. Subsequent thereto on 1/8/2024, charge sheet in the present case has been filed. In view of the changing circumstances, petitioner is liberty to ring the bail plea for the bail plea is filed, which shall be considered on the basis of the material form part of the charge sheet. Yes, next.
29.
What is the guide there?
And your antecedents are there. Yes, next.
No, ये पिटिशन नंबर 2 में किसी नहीं इंसिडेंट ये ऑप्शन
Yes, next.
मतलब ये पिटिशन नंबर 2 के एक्चुअल रिकॉर्ड में समस्या मतलब that's again
Counsel for the petitioner submits that in so far as petitioner number 2 is concerned, there is no criminal antecedent. Although against the petitioner number 1, how many criminal antecedents are there?
21 numbers, my lord.
21 number of criminals. Therefore, he pressed for the bail plea of petitioner number 2. Petitioner number 2. I am not inclined to enlarge the petition on bail. However, liberty is granted. Yes.
मतलब पिटिशन नंबर 3 ना record
I passed the charge sheet is filed. You go and tell. Nothing is there except the FIR. Yes.
no injury my lord my
Anyway, next. Yes.
But yes. The last day, inclined to grant bail only because of that notice part. Principal adjourned for today.
Notice.
What is
Mission service?
498, 376. They married in the year they're having in the
Service.
Yes. 26/9/24 my lord.
Okay.
Informant also appeared in this case, my lord, in this my lord.
Yes, you are appealing. Informant. Okay.
May I please?
Yes.
Relationship.
Yes.
30.
Can you write down his what is his name? Sanjay Sirao. Sanjay Sirao. Is it? Sanjay Sirao. For informant. Yes.
Maybe, sir.
33-0. Yes.
Maybe, Lord. Here, my lord, item 30 and 31.
Yes.
In both the cases, my lord, the petitioner is same, my lord. He was remanded in those cases, my lord. Kindly have a glance. I have filed the affidavit that is on F. Flag F, my lord.
Flag F.
Flag F.
Yes.
My lord, in second page, my lord, I have given a table, my lord. Initially the present petitioner was arrested on 14/3/2024. He was cyber crime and economic offence so and so.
Yes.
For commission of offence under section 419/420. He is on bail in that case, my lord. Subsequently, on 28/3 and remanded in 2 other cases and 8/4 in another case.
Yes.
While he was in custody. Yes, my lord. And out of those 4 cases, he is on bail.
Pending. In one case, you release on bail.
2 cases, my lord.
2 cases you release.
Yes,
And these 2 cases are there.
Pending, my lord.
Yes.
And as per my lord, in BLFL 5517 is concerned, my lord, that is the allegation of 25,000 of misapprehension.
Yes, sir.
And
My lord, even my lord, the background of the case is that when the complainant come to withdraw money from SBI ATM counter, my lord, before his arrival of one of the associate of the petitioner, my lord, are waited in ATM counter in front of the ATM, spreading his cyber fraud net to cheat the bank account holder. The accused Asad petitioner had waited with his 2 associates, my lord, some distance, my lord. When the complainant went and inserted his ATM card in one ATM, then as per planning of the petitioner, my lord, the ATM card of the complainant kept inside the ATM, my lord. Then the associate of that petitioner, who was present in front of the another ATM, told the complainant to connect the helpline number, that is so and so, whose number has already been passed the body of the ATM, my lord. Then as per their planning, the person who got connect as customer care told him to come out of the ATM counter to avoid voice fluctuation, and then subsequently the complainant came out and made a conversation for around 2 minutes, my lord. During this time, the associate of that petitioner, my lord, who was present inside the ATM counter in front of the one of the ATM change, my lord. In the meantime, he changed the chip of the ATM card, my lord. And again inserted inside the ATM after the conversation about the complainant went inside the ATM counter and brought his ATM card. And when he again tried to withdraw money, then he felt, then he came back to, then after the accused person succeeded to withdraw an amount of rupees 2,65,000, And that withdrawn, all amount has been withdrawn by the petitioner. Who is the main prime accused, my lord?
He is prime accused.
My lord.
What about the other accused persons?
My lord?
What are the other, what about the other accused persons?
Other accusations are not been accepted, my lord. They are what, until the investigation is open, my lord.
Charge sheet has not been filed.
Yes, madam, charge sheet has been submitted.
Preliminary, my lord. That, my lord, here, my lord. Other accusations are yet to be arrested, my lord.
What about the, and what is the evidence except the confessional statement? All these things you might have recorded on the basis of confessional statement.
My lord.
What are the evidence you have got?
And apart from that, 4 numbers of antecedents are there, my lord, in this name.
He was arrested.
And he is a man of, my lord, that Delhi, my lord, Faridabad.
How much time will you take to complete the investigations?
My lord, it will be taken up after vacation.
I am submitting, my lord. Can you have a glance? In the 4 cases, my lord, I have secured 1 lakh rupees in the first, my lord. And in another case, which case I am remanded, I have secured 5,000. And thereafter, I am ready to secure 25,000. In the second case, that is 5517 of 24. In that case, allegation of 25.
No, in Orissa you have 4 cases. Across the country, how many cases?
No, my lord. I am the, my lord, cloth trader, my lord. Cloth.
You just tell me across the country how many cases?
Yes.
Because this is what is the big problem. You are not now.
My lord, I am arrested. There are 1 case.
You tell me in other state how many cases are there?
No, my lord, after my instruction,
No, you have to tell me because these people go to different state and they come with this kind of cases.
My lord, in this 1 case, my lord, only I am implicated in 1 case, my lord. While I was in custody.
I understand. Don't repeat it. I understand it.
Yes, sir.
I understand it. You just tell me, seek instruction, tell me, in other state do you have cases or no?
No, there is no other problem.
No, you don't tell like this. I know 100%. 100% okay.
I will see the record.
Yes.
Last time I was arguing the class that in other states also they have 25, more than 25 cases are there. They are coming to a state and
this is what they do.
Again 10 days they will return to another state.
Every state they go and do matter.
If there is
then counsel for the petitioner is direct to file an affidavit detailing the number of cases registered against him across the country, leads the matter after the case. Yes. File an affidavit. No.
32.
SCD is there, madam.
Yes.
25 pages on the petitioner is a man of Rajasthan, madam.
Antecedents?
Antecedent, madam, that instruction, no criminal antecedent is there, madam. That
file affidavit subject to verification of my.
No. If I then move application, you will go to Mr. Mishra. Mr. Mishra, that's the same thing.
So that was not a case where I had not I had disclosed. But
so you have disclosed, he is not disclosing. So let the petitioner file an affidavit disclosing the antecedent, criminal antecedent the petitioner has, is the matter.
33.
And if you disclose, then whatever you are arguing, that will help you. And utilize that judgment and yes. 33.
Offense number 376, 511.
376?
511, madam. Expositions, madam, 75, 2024.
376, yes. Yes. Custody since?
75, 2024.
24. Yes, sir.
My lord.
You have CD and all?
Yes, yes, it is there, my lord. There are 164, my lord, that statement in here. I'm uploading.
Very good. Done. I'll upload it. Yes.
It is common, my lord.
Immediately, yes. Immediately application. Yes. Yes.
Maybe. It's a case under section 341, 323, 307, 34 IPC.
Yes.
And the petitioner is in custody since 5 to 24, my lord.
5 to 24.
Yes, my lord.
Yes.
Kindly have a glance to the last order, my lord.
Yes.
That is 29, 2024.
Yes, what is the health condition? Have you sought the instructions? The last order, 20th September.
Ascertain that injured is still in treatment at High Tech College and Hospital on 11/9/24. The injured using wheelchair and is immobile assaulted by the accused person and his health condition is not good.
No antecedent,
maybe 302, I don't know.
Due to sudden provocation,
whatever, you have injured the man like this and he become completely immobile. What are you talking?
3 persons are there, man. I am placing the
December. Let him be released from the hospital. December.
36.
Me, my lord, this is a case of section
December last
365, 202, 201, 34 IPC.
Yes.
The petitioner is not named in that law. There is no IPS to reference. The only material against the petitioner is own confession before police and leading to discovery.
After the minor directed present copy of
Statute can put a visible nahi they can really. Visible nahi. That's why I could not. ମୋ ପାଖରେ ଯୋଉ ଚାର୍ଜସିଟ୍ ଟା ଅଛି ସେଟା ଟିକେ ଭଲ ଦେଖାଯାଉନି. It is the
you have CD. You have CD.
ଚାର୍ଜସିଟ୍ I am ଦେଖି ଦିଅନ୍ତୁ ଚାର୍ଜସିଟ୍ ଟା.
ଆଉ ବି କଣ ଦେଖିବ ନା ଭାକେସନ ପରେ ଆସିବ.
Case date ସେଟା ଚାର୍ଜସିଟ୍ already filed before filing of this application.
No, what are the offences?
My lord, 365, 302, 201, 34 IPC.
Yes.
Custody since my lord. 2023. 9/12/2023. 23. What charge sheet submitted on 3/4/2024. 3/4/2024.
Okay.
And I filed this application on 24/6/2024. Before this report.
Yes. Without charge sheet, how we can decide it?
Well,
except FIR, there is nothing.
But the case study, but when the case study was confirmed, just see why then what are the allegations?
Yeah, allegation lord. Complaint category.
Sanjil Pradhan.
Deceased have been kidnapped on 26/11/23 on 8/2 8/12/24 dead body was found Miller. Implication of the present petition Miller, number of CDR Miller, call details revealed Miller at the time of occurrence was at the spot. Then Miller, dead body was recovered on the instance of the petitioner took the police to that pond area where he was concealed the body Miller. On 8/12, dead body was recovered, rather leading to discovery statement. Then Miller, postmortem report says asphyxia due to ligature Miller. That is homicidal in nature.
Yes.
Mercilessly kidnapped thereafter kill Miller and body was found after 8 days.
I am not disputing that. But what is the material against the petitioner?
Dead body recovered.
Except dead body, except own confession before police. But during investigation,
if the weapon of offense is recovered at the instance, there is some doubt. It can be implanted. If the dead body is recovered at the instance, that is very dangerous. 27 recovery dead body is very dangerous. During the weapon, I have all doubt. The weapons are generally planted. To substantiate 27. But when the dead body is recovered at the instance, then 27.
But in this case, during investigation, some witnesses were stated that there was enmity between the deceased and a.
How many witnesses, recovery witnesses? Only two.
charge sheet copy तांशी कोई
Recovery witnesses. Recovery witnesses.
And
Let me file the charge sheet, whatever is legible, you give it to him. Because 302 give it to him.
Well, then after
the sheet after the case.
That may take in the meantime.
Yes, you should do. You give it to them. Yes.
Only charge sheet statement.
Yes. 37.
No, please, Your Honor. The recovery of hero 83 grams below commercial quantity, my lord. And 2.6 something cases are there, not of similar nature. Those are the dealers dispute cases, my lord, where in 3 cases he has been acquitted. 3 cases are pending where he is on bail, my lord.
Similar and not similar.
Not similar in nature.
Yes.
All the cases I have given the chart, my lord.
Yes, it is there.
My lord, I have given the update.
CD. Below commercial quantity. Better, no similar incidents.
CD available Millard. Last year, money that is to file a
affidavit. He has filed affidavit.
Yes, yes, filed the affidavit today.
Yes.
83 gram again.
83 gram. Petitioner custodians.
Custodians, my lord. 1/6/2024.
1/6/2024. Persons to the order dated, person dated 3/10/2024. The petitioner has filed an affidavit on 7/10/2024, disclosing that he has 6 cases. 6 cases, but all the cases are not cases involving offense under NDPS Act. And all the 6 cases which has been disclosed, in one case, the petitioner has stated that he has been acquitted, and 3 cases he has been acquitted, and other 3 cases he has already been granted bail. The recovery is, what is that recovery? 83 grams. 83 grams of brown sugar. And regarding to the period of custody and quantity of contraband use, and the fact that the petitioner is not involved in any similar offenses. Yes.
38 maybe 38 kg ganja, 4% in a 38-47, 50 kg ganja, 4% in a big kit. Is there?
No, CD is a charge sheet copy, not
final clear henge 4,000. You have filed affidavit? Affidavit, we have no, just no affidavit. On verification, man. No, you file affidavit. Verification, then again, no, you file affidavit. I will go by affidavit. Then tomorrow, we are छुट्टी पूर्व 50 किलो गंजे रही Durga Puja छुट्टी.
Oh no, I have experience because wherever I have given, applications are coming. No. Therefore, now I decided that when you file affidavit, I'll record it and grant it. It's a program second action. When you say that, then once I give the bill, then all these things comes. Criminal to the court.
Case of the name and file affidavit.
Let me open also. I will open.
Right. The final filed affidavit. Affidavit disclosing the antecedents. At the meantime, the letter counsel for the state where is the SSL producing charge sheet. 20 seconds. 20 seconds. Yes. 13
पूजा छुट्टी है 50 किलो रो
during vacation
अक्टोबर आउट होबे खाली जितने ଭଲ ହେଇଥିଲା ଛୁଟି ପୂର୍ବରୁ ସେଇ
20 seconds file affidavit. Yes.
39 3 to CD is required.
CD call for CD. Sir is sitting since morning. 41. Yes. 41. You are done. Yes.
My lord, here I am for the petitioner.
Yes.
I seek for cancellation of bail against the opposite party on two grounds. Primarily, that the conditions which were imposed have not been complied at all from 2018. Now we are in 2024. 6 years he has been utilizing his liberty.
Yes.
Secondly, at present, there is evidence before your lordship that how he has flouted the condition by not allowing the allottees of an apartment to of a the project go into the project itself.
Is he the builder?
He, the opposite party is the builder. So now,
What are the first condition? Not complied. Show me the condition first, huh?
yes, the bail order.
Yes. I think,
22.
yes, there I am there. Exactly there. Yes. Condition is settlement.
Yes. This 22, if your lordship at that page.
Yes, I'm there.
Now that the settlement has been reached between the petitioner and the investor, of the view that the petitioner can be released on bail subject to the conditions that he shall abide by the conditions agreed upon. So what are the conditions?
Yes.
That is there in the joint affidavit.
What is that?
Joint affidavit is at page 12.
12, huh? Yes.
The conditions start at page 30.
The joint affidavit dated?
This is dated 25/4/2018.
25/4/2018.
Yes, my lord.
And bail granted on?
Bail 20, this is 9/5/2018.
Why have you waited?
No, my lord.
For 6 years?
Yes, I will come to that. In between, he did not comply with the orders. Then we went to the through the process that RERA was not in place then. That the regulatory and the estate authority. We went there. RERA found that he has swindled money. He is misutilizing the liberty granted by the court.
Sorry, my lord.
This, Mike. Yes. Yes.
He has swindled the money, misutilizing the liberty granted by the court. Then he went. Before that, RERA made an execution order that he did not comply. In appeal also the court found that he has shouted the order. He is not registering itself. He has not allotted the allottees the promises which were made. The flats in a habitable condition is also not there. Thereafter, I came before your lordships when we went. And he has filed now an MSA. There is no stay order. MSA means
What did he say at the time?
The has not yet commenced. It has not yet commenced. Now your lordship,
See, at this late
the situation is this annexure 7.
7.
Lordship may see.
Okay.
This is what we gave in writing
Yes.
to the builder that we want to engage a third party agency because you are not complying anything. We are not even able to go and reside at our apartments. It is not an habitable.
These are subsequent dispute. I can't decide on the cancellation.
No, my lord. This is something is not doing and go. Remedies are there. No, that remedy is already. No, the conditions which have been imposed is that he will allow us. He will make the apartment habitable condition. That is the condition in the affidavit. That I'll show. That your lordship may see now what he has done. Annexure 7 is our letter. Please allow us to go and reside in a habitable condition. We will engage a third party agency. You don't have to interfere.
You are the resident.
Yes.
You are informant.
Yes.
You are the informant.
Yes. The association.
No. Who is the informant?
Informant is the association.
No.
The
Who are you? Who are you?
I am the association before your lordship.
Show me the authorization.
Your lordship may see.
Are you a party to the settlement?
Yes, yes. The FIR was given by the association itself.
Sum it up in 1 minute.
Let me understand it first of all. Who has signed it?
See,
Who has signed it? Let us see.
the treasurer, 7 Hills Estate Flat Owners
And who is
Association.
the author of the FIR?
Author of the FIR is the association itself.
Nobody that.
Page 11 they have signed and but is there the
No. In the FIR, just see the FIR. Who is the complainant? Informant.
It's the treasurer.
The association.
It's the treasurer. My lord.
That's technical, my lord. That is hyper-technical treasurer.
Therefore, sir, if the informant can come and ask for the cancellation of bail. I understand the association is facing some problem.
This is the
association are like that. What to do?
No, because it is a different case, but
One thing. Let us find out a solution. I know there is a dispute, and you are utilizing this platform for the purpose of settling the dispute to existing dispute. I will tell you to mediation, get it done, finish it up. Without me peacefully, that's the best way of doing it.
But before that, let me go to my residence, my lord.
Can I try to appreciate one thing? Can I, in a cancellation of bail, can I go into all these things?
Yes, your lordship, that is the liberty.
Yes. Because the law is taking change. Now Rera thing came, this came, that came. All this this is not an adjudicating jurisdiction.
My lord.
It's not adjudicating.
Bow down to that, but Annexure 8 is the supervening circumstances which has arisen. That is why we have come.
So I'll give you the liberty to go to trial court. 8 is the supreme application to trial court. I'll give you liberty, let the trial court.
What the bail condition was that in case he flouts any condition, then we will have the liberty to approach your lordship by saying this.
That is my lord. That's the law in one paragraph of the order.
Page 22.
Last but one paragraph. Now we have settled.
Your question is page 22, the second paragraph, the last 2 lines. The conditions agreed upon, besides taking care of the request or interest of any specific or individual investors, and the parties would be at liberty to approach the court in case of failure in compliance thereof.
Approach the court.
Yes, this court.
It doesn't say that approach cancellation.
This is because the conditions have been imposed by this court.
No. That is adjudication, complete adjudication. The rights of individual investors will be adjudicated in the court of law. And grant of bail will not preclude you to approach the court. That's the idea of
What is this court? Because here that has been clarified in this paragraph itself. I'll read out again from the very first line of that paragraph.
I understood everything. Tell me the solution.
The solution is the dispute.
I will tell my lordship the solution. Look at 3 of the addendum. 403 of the or 362 of the criminal procedure code. Wait.
Let
I will read it out.
Take
each brother. 403.
I'm not cancelling, but I'm saying try to find a solution.
Lordship, 1 minute. 403. Not judgments.
This is not a judgment, sir.
No, my lordship says, same as otherwise provided by this Sunil or any other law for the time being in force, no court will sign the judgment or final order disposing of a case shall alter or review the date except the condition. That is number 1. Okay, number 2. My lordship would say, I've given a reply. There is an arbitration clause. And they have abided by the arbitration clause. My lordship says, my lordship will turn, I have given my copy, my lordship will turn to page.
Much water has flowed because
page 12.
The forums have gone.
Wait.
Forum in the agreement itself there is arbitration clause.
That is absolutely out.
Where is that?
Page 12. Page 12, 33.
33. No, come to the page. Not 33. Where is that arbitration clause?
given a written reply to.
No, come to the.
Acha, to the, this thing. Okay, the agreement. Agreement, my lordship says, it is in the, they have not annexed the agreement. I will read out the agreement, my lord. Each one of them signed in the agreement it category 50. All disputes and differences between the parties pertain to any of the matters connected therewith, relating the flat, this agreement or any other dispute, it is specifically agreed and accepted consciously by the second party.
That will not at all. Now Veda has passed the order. He has not registered.
No. Cancellation is not made up. You tell me.
Your lordship,
you tell me the solution. I'll do.
Supervening circumstances. That is where my learned. I'm not advocating here. No, what has happened? He's not allowing
On the basis of supervening circumstances, can I
particular
giving no clean certificate. I'm not going to do all these things. I'm not going to do all this.
What I propose in the meantime, my lord, the lordship,
I can send you to mediation, but that's all. Beyond that, I can't do anything. If you think something in
appreciation. Your lordship may also add one with your lordship. I will go and sit with again the mediation much. Because the resorted to section 11 and all. That is no more, that is not in picture at all. Because after all the products, he fall back on the agreement now that
I don't know. I am the basis of the
given on the judgment. In the judgment,
I understood.
Violation of condition. So it's taken by that way.
No, I will not interfere. I will not interfere.
Only one thing. Only one.
I am rejecting it. If you don't want,
my proposal is subject to my learned senior will also accept that. We will go into the apartment and stay there.
Sir, am I deciding in English? 3912?
See the conditions.
Order 3912 application?
The conditions are.
Or it is 439 cancellation.
My lord, the conditions stipulate that.
I can't pass on a mandatory injunction or any kind of injunction which you are asking in the garb of cancellation of bail.
The condition
after 6 years you have come. After 6 years you have come on the changing circumstances.
Yes, so
I can do one, two things. If you want to move an application to the trial court, I can use that road to go and move whatever you want. Sending to mediation. But when we go to mediation and finish it up.
Your lordship will keep this pending, direct me for mediation.
I will not keep pending.
Then I will keep it pending.
That's secure. The problem is, if you come to any family, is receipt to us. Battling 400 families, actually it's in 400. It categorically states. Sending it to mediation, we are working.
Then my lord, the submit. Because supervening circumstances
that's unfair and to this thing to write supervening circumstances, the bill will be cancelled after 6 years.
My lord, Supreme Court, my lord, also the very recent judgment, my lord, your lordship may see.
They cancel the bill after 6 years.
Yes,
supervening circumstances.
Yes, because
what are you talking?
Yes, my lord, I will just read it.
What are you talking?
My lordship,
this is regarding
my lordship says I've underlined.
Granted may be cancelled. It is found that the persons who have been granted the benefit of bail has violated any of the conditions.
Then is not violation. That is the reason the court says that there is an arbitration clause. And granting the bail, notwithstanding the fact that bail is granted, you are not able to proceed. Investors are not stipulated to proceed. That is what the order is. And you are not even complaining. You want an adjudication in the cancellation of bail?
No, the informant is the assistant.
No, what is the name of the informant? Who signed the FIR? No. Name of the company.
Page 11 your lordship must see, that is the informant is the assistant.
No, you FIR. Who signed the FIR? Yes, about treasurer, where is Manoj Kumar Kadagi? You told me which box now.
Then I have also, my lord, the application for last night, my lordship directed me.
Don't Manoj Kumar has signed. Has Manoj Kumar authorized you?
Implement of party, that petition is also ready with me. Another informant, Vasudha Mishra. She is a lady. She is also.
Why are you stretching so much, sir?
She have directed me to implement another informant. That also I will get government comply with all the orders, but
I think.
After vacation. December.
Margit, 44. 43, yeah?
May I please Julius?
Yes.
Here, my lord, petitioner challenge the order dated 17/5/2022 passed by the Lorraine JMFC Kollikot, wherein the Lorraine JMFC Kollikot has been pleased to refuse to take cognizance under section 302 IPC, my lord. The background of the case is, my lord, the petitioner being the informant. My lord, the petitioner being the informant has filed an affair before the police station regarding administering poison to her sister, my lord. Thereafter, my lord, instead of registering a case under section 302 IPC, the police has registered an UD case. Agreed with such action of police, then the present petitioner has filed an 1CC case, valid 1CC case number 27/19 before the Lorraine JMFC Kollikot. The Lorraine JMFC Kollikot has sent the same under section 156 of clause 3 for registration and investigation of the case. Thereafter, my lord, investigation was started. And after completion of investigation, my lord, I was submitted the case as mistake of fact, and so finally, mistake of fact.
You filed protest petition.
I filed the protest petition, my lord. 8 persons, 8 witnesses have already been examined. The lordship of glass to page 87 starts, my lord. All the witnesses have categorically stated and supported the prosecution.
Issue notice, let us. Issue notice. Yes. Issue notice. Yes. Next.
Item number 44.
In this case, manner, we have filed an application for execution, internal application for stay matter. And this one was pleased to issue notice and stay. In earlier case matter, CMC number is execution case number 37 of 2020. Thereafter, he has filed a execution case matter 10 of 2022. Now, what is the main matter you just? Main matter, maintenance. Maintenance can't be stayed. Duty proceeding against us. Maintenance can't be stayed. You have to keep on paying maintenance. Execution proceeding. You are paying for? I am the opposite party on sorry? You have sorry? What is no, my lord, I have already. No, you have to keep on paying maintenance. Maintenance cannot be stopped. Maintenance, I have already paid, my lord. No, you filed 2019, you let him file the reply. My lord, where is the proof that you have deposited? Regularly you are paying. My lord, we have paid, my lord. No, you show me the proof that you are paying. Let's kindly see the order, my lord. Dated 21/11/2023, my lord. 21/11/2023, my lord. This Hon'Ble pleased to 20,000 rupees you deposit, my lord. Yes, that they are not paid. They did. 2023 you have already paid. No more 2023, 20,000 rupees you have already paid, my lord. Show me, but that's what I'm asking. I have showing, my lord. Keep it, my lord, after vacation, my lord. That's what, yes, I have showing all the details, my lord. Children protection, my lord. Yes. Next. What children protection, my lord? What protection? You have to keep on paying. Maintenance can't stay like this. Already I have paid all. That's what I'm asking you. Show me that you are paying. So that I can pass some order. Yes. 45. 45?
Sir, your order my order. Procedural for my order. Yes, you have to direct to the IAC to appear of the AC my order.
Nobody party number two.
Yes.
Yes.
Yeah,
Now, what is this case? This matter on the 23rd October. 23rd October.
इंटेंशनली 23 अक्टोबर तक डेट दिया ना अपन अपन कह देबे ठीक अछि
Sir,
23
sir. Sir.
23 अक्टोबर रे बंद रखी रहे माने
Sir, sir. Sir.
My prayer is
Yes.
I can 46.
There is a change. There is a
No stay.
23rd will see possible.
Yes, sir.
He may not be interested now.
May not be interested.
Yes. 46.
Yes, 46, man.
46, Your Worship, we have issued for fresh requisites for opening number 2.
Yes. Service.
Sir, you getting acceptance, sir. Later.
We find them.
Requisites to serve opposite party number 2 it was filed belatedly, therefore subjected by the opposite party number 2 may be served. Yes. Yes. Next.
Your Lordship, before you pray, if the matter will be sent to mediation.
No, sir. You don't sell, you don't file requisition asking for anything more. Yes.
I don't know. The rent.
47, huh? That also will do. Before that also you can do. What is this doing now? Are you serious? What is this matter?
My way under section 492.
September 22 combination statement. What is this saying now? Now charge and everything might have been framed.
Definitely. Yes, sir.
Tradition on request. In the last date of hearing on appeal, when the matter is taken up today, there is a request on behalf of the petitioner for adjournment. First, the matter was taken up on 13/5/2024. The petitioner sought an adjournment. Subsequent thereto, when the matter was taken up on 2/9/2024, none appeal for the petitioner. Today, there is a request on behalf of petitioner for an adjournment. In the interest of justice, adjourn to December last. Yes.
This is relatively life. Now,
and I was extremely and accepting the question of the author also consider proceeding in the other yes. That depends on answer
What she wants. She wants if the minister passing up to certificate alone. Is present in person, present each person along with the IO of the case, with the IO of the case. So entered appearance on her behalf and seeks time to file response. Vokalatnama is taken on record. This is the matter of so. Yes. Next time, you may not come.
I will dispense my
dispense. I'm going to what is through lobbying. Two large.
May I please your lordship? May I please your lordship? May I please your lordship?
Yes.
My lord, it is under section 138 of NIA.
Yes.
Before the trial court, my lord, when the evidence was closed from the side of defense as well as prosecution, the accused filed a petition before the lower court.
1 minute, 1 minute. What's the service of notice? Yes, yes.
Item delivered. From delivered on 26 for 20.
Yes.
My lord, when before the lower court, when the evidence was closed, both from the side of complainant as well as accused, my lord, the accused filed a petition before the land trial court requesting therein to send the check to the handwriting expert, denying the amounts and the content therein. And that was rejected by the land lower court referring section 20 of the NIA. And thereafter, my lord, the accused filed a revision challenging the order of the lower court, and the landed session judge, totally ignoring section 20 of the NIA, allowed the revision against which this CRLMT has been filed, my lord. What section 20 says, my lord, that where one person sign and deliver to another a paper stamped in accordance with law relating to negotiable instrument, then in force either wholly blank or having written thereon an incomplete negotiable instrument, he thereby give prima facie authority to the holder thereof to make or complete, as the case may be, upon a negotiable instrument for any amount specified therein. The person so signing shall be liable upon such instrument in the capacity in which he signed the same to any holder in due course. My lord, I have also filed a decision of the recent decision of the Honorable Apex Court, my lord, comprising the present Chief Justice of India, Honorable Justice Y.B. Chandrachud and A.B. Bopanna, by an extra right, my lord.
Please hold on. You will not tell the name of the judges. Supreme Court and Supreme Court.
କହିଛନ୍ତି ସେଥିରେ sir ଯେ ଏଥିରେ କହିଛନ୍ତି ଯେ evidence of handwriting expert annexure 5 my lord. The handwriting, the head portion, the evidence of handwriting expert on whether the accused had filed in the detail in the check would be immaterial to determining the purpose for which the check was handed over. Therefore, no purpose is served by allowing the application for adducing the evidence of the handwriting expert. Further, the Honorable Apex Court has held, my lord, that the presumption which arises on the signing, even if the detail in the check have not been filed off by drawer but by another person, this is not relevant to the defense whether check was issued towards payment of debt or in discharge of liability. So, my lord, the order passed by the landed session judge for handwriting expert is in totally in contravention of section 20 of the NIA, my lord.
Yes. But the opposite side has not come. What? There is an entry.
Postal tracking report confirmed delivery, my lord.
It's all right. Entry order is operating in your favor. Still in the entry order. Let it continue. Then it is for the opposite party number 2, despite service. In the interest of justice, urgent to so and so, the entry order passed on 15/4/2024 shall continue. Yes, next.
I don't want 51. The notice issued of both party opposite party 2 and 3. 3 returned unserved with an endorsement not located. Hence returned to the brother of the Lakshmindra press service.
I have applied for OP number 2. Today
the so entered opinions for opposite party number 2. So far as opposite party number 3 is concerned, the notice could not be served for want of proper address. The petition shall counsel for the petition shall file press addresses and process for the purpose of issuing notice to opposite party number 2. Is the matter. The opposite party number 2 name. Yes. 50 and 52. No, 50. Yes, next. Requested them, yes.
Application, they have filed certain additional documents.
Come December 1st week. Yes.
Even also, they have not supplied me the copies of
53.
53, they have, the Learned Council, your lordship directed them to take all the things you bring out.
Simply let them to December. We will see that day. 53 also, December. Yes.
54.
54.
Last occasion also no.
54.
Last appears. Compromise matter.
Right. I'll dismiss it. The matter was taken up on 3/10/2024. The following order was passed. Today, when the matter is again called non-IPS for the petitioner, it seems petitioner is not interested to prosecute the matter. Accordingly, it is dismissed. Yes. Yes. Dismiss.
25. Dismiss.
Last time nobody appeared, and I have passed a peremptory order. Yes.
55 prayer this pattern will be distributed with the public. This will take a stand before Parliament trial court at the time of
Learned Counsel for the petitioner seeks to withdraw the present petition to raise all the points before the court below at appropriate stage. With this liberty, the petition is disposed of. Yes. So blessed.
56.
The cases were pending since 2015.
From that stay order was there. That
15, 16, yes.
Yes, sir. Also, there are facts actually died in the trial court lots. It has been lingering since then. Your lordship, it was filed in 2023. And after that, there is an interim protection. And when you are appealing for whom? Property part number 4. Who is appealing for the petitioner?
I am there.
Silently you are there means there is something.
No, he wants to have some say. I don't know what he wanted to say.
He wanted to say that this matter we are enjoying the interim order.
This matter should not linger further because there is the interim order. All matter of facts. Facts cannot be adjudicated. That is what he said. I am simply simplifying that.
And therefore, the interim order anyway should be vacated.
No, that has been said. We don't say that. It should be dismissed. Avoid that far. Why should I come back again without interim order?
Yes.
My lord, then look at page 15.
One side?
One side, sir.
Yes.
That's a complaint case number 138. Transaction is one. Amounts are almost same. Some difference here and there factually. That I had taken a loan from him, hand loan. Sir, 17 sir, 2 lakhs, 2,000 and this after the amounts I had taken, issued a check got bounced, for which he has initiated a proceeding. This is that case concerning 3791 of 2021. Now with the said same of facts, because one of the checks, there was a time expired for presentation or something. So he comes up with a brilliant idea of saying that I wanted to purchase a plot, or he wanted to purchase a plot, some advances were there, that is there here. So these are the contradictions he says, which are factual disputes he says. Am I clear or something?
I am clear.
So on the basis, how can you have two stories on the same case?
Which story is correct?
420 Halani to 138 is pending.
130, 420 can go together.
Can go together, it's different.
Those things will be tested in trial. How can I? At this stage, if I am coming at any time, sir, who knows better than him?
Even landlord is.
If you would have been appear in that side, you would not allow to open him out.
Even itchy night, sir, it was
that's the problem.
Schedule
These things, can I?
Yes. Once is a case, no.
FIR ଅଛି.
I will not enter, but I will send you to mediation. But exactly.
Mediation ର କିଛି ହବ?
It's right.
Let's make it right.
You go and you go like it. I will send you to mediation. Whether you pay, the amount is not much, 2 lakh rupees. And you might have spent more than
Nice, sir.
unless this is
Mediation there.
mediation, whatever. Mediation. You try and finish it up. Mediation. Okay. Okay.
Till then,
Awaiting mediation report.
protection may be continued.
Protection is that will continue.
Sir, ଗୋଟେ ପରଦିନ ନା କେବେ ଲାଷ୍ଟ ୱିକ୍ ଗୋଟେ ବେଲ୍ ଟେ ଏଲାଉ କରିଥିଲେ ସାଟରଡେ ବୋଧେ.
I will be, see, because of the schedule, you know that. It's not, I'm getting it done by tomorrow day.
ଆଜି ଯଦି ଅପଲୋଡ ନହେଲା କାଲି ସାର୍ଟିଫାଇଡ କଲେ ସେ ବାହାରି ପାରିବନି.
You see that all the bail orders are uploaded.
ସବୁ ବେଲ୍ ଅର୍ଡର କରିବେ.
So, court, there are a lot of engagement.
ନାଇଁ ସାର୍ ମୁଁ ଜାଣିଛି.
That's the problem. Yesterday, 11 o'clock, we came back. What to do? From 4:30 to 11 o'clock.
Pen drive sir.
You give the number.
Number sir.
Number you just give all the data. We try to get it done today itself. Subject to waiting time. Yes.
We don't know 57.
Yes. 57. Then after the notice by instruction to implement mercy. Yes. Because you were to mediation portfolio or consent from both the parties. If we everything mediation to court, list it. Okay. The last to the notice by instruction to implement mercy. We see the police. This house, you find this response. Let's check it up. Some 6 9 to 10 20.
Working regarding this. Getting this notice sufficient.
Okay, sufficient.
372.
372.
Notice sufficient.
Yes. So, I'll do it immediately after notice. Somebody will appear. I will do. By order dated 4/9/2024, notice was issued to the informant of the complainant. The notice had been served on the opposite party number 2, but not on the PS behalf. In the interest of justice, urgent to show. On submission of plan petition that will be allowed. In the meantime, the petitioner is given liberty to move application for the trial court for pray for adjournment. If the matter is taken, the same will be checked. Yes. Yes.
Item number 58. Sorry, 58 mentioned.
58 mentioned, okay.
59.
58 somebody mentioned. Yes. And yes. Yes. Yeah. It's a squarely covered matter, but issuing notice also have indicated in the issuing order also that this is squarely covered matter, and because the trust was not made as a party. And in the capacity of chairman, we are back in 2014 only this take for this tool. What opposite party number 2 is sir? Opposite party number 2 is. I'm going to putting up. No. Who is appealing for? Opposite party number is the complainant. See, there is a to serve opposite party number 2. Service, check it up. Service is complete. Service is complete. Just check it up. Service. Check the service. Opposite party number 2. One Samanandra Mahanti. One Samanandra Mahanti already appeared. Yes. Yes, this is squarely covered matter. The Divya Manjari Satpati, your losses only indicated at the time of issuing notice. Okay to appear. So, they have already done. If this is the fifth time the matter is now. 4 times to go beyond the date of the petition. And round up correction. 59 round up correction. List of the 59.
Somebody was mentioning, but.
Somebody mentioned, I said that let the petitioner come.
But it is completely squarely covered. We see the last paragraph. The court was not made as a party in this matter. So the complaint itself fails. It doesn't.
But in the presence of any notice,
Mr. But somebody mentioned doesn't look nice in front. Yes, yes, I'll keep it on 30. Mr. Samendra Mohanty, advocate for opposite party number 2, had mentioned for adjournment in the first hour. When the matter was called up, Mr. Tripathi, for the petitioner has submitted that behind he has not been informed. He has not been informed regarding the same. Be that as it may, in the interest of justice, at the which date you want it? 23rd. 23rd. Keep it on 23rd. And that day you should take it.
I'm something on 25.
Yes.
Yes. I was seeking an opportunity to appear with the welcome any day. Yes.
Yes. 60.
I don't know, 60.
Permanently also a party.
Yes.
I learned from the reference. Now what we should go to the sides to explore the possibility of a settlement between these young.
That would be the reason that I had conversed to my mind similar yesterday. My local instruction and whatever
She will suggest.
What is the offense?
The offense was preparing law. And now there is a and somebody.
And second, the action of mediation. If you want. Although you simply and the immediate classification you tell me. You tell me it's possible, I'll send it to mediation.
my young friend will be able to capture informant also. Because you might file 482 and get it back. But I have not open discuss anything because we are not something else.
Both the matters, I'm sending to mediation, and you will finish up both the matters. Simply exam on the report. Now, 25th. By that time, you seek instruction. If possible, file a petition and tell me the number and tag it.
The others for Germany because of actually. Unless you come, then it is not possible.
Let him appear on VC, I will accommodate, no problem.
Then I thought the council has interest in it.
Let him, even if you appear on VC, I will finish it. Okay. Yes.
I don't, 61.
61. Non-appeals for the parties in the interest of justice at that. Oh, there is no more last day. Okay. Yes. 62. Yes.
Father-in-law, mother-in-law are before your lordship. In this case, for passing of the proceeding, in trial, the husband has been acquitted. Husband has been.
You are acquitted. Both of you are acquitted. That's what I'm saying.
That has been shown as absolutely because.
What are the allegations of father-in-law, mother-in-law?
And all the.
Is there any? Father, the husband has been acquitted.
Rather,
they are the old parents, 67, 70 and all.
Rather, they have
304B. 304B, the 192. Let it be whatever. This is what I'm staying the proceeding. Let it come.
They are clearly stated in their.
It's all right. I'll stay the proceeding. Right.
All the notices are become what type?
Tell me the particulars of the case.
Notice subsumed is
Notice to the opposite party number 2 was issued, and despite service of notice, none appears for the opposite party number 2 in the interest of justice urgent to so and so. In the meantime, the order passed on shall remain operative. Remain operative till the disposal of the petition. Yes.
Yes, no. Item number 64.
And give me date in December. Let it go. Yes.
No. I don't.
Let it come. I'm staying with let it go. Yes. It will die of its own. Yeah. Yes.
Item number 64.
Yes.
Your Lord, that the mediation, repair mediation successful.
Successful. Well, very good. Very good. Shall I cross it now?
Only 506 is been on the level of concern.
Now mediation, this is the best of settlement. Where is mediation?
Their matter, dear Lord.
Final mediation.
5/10/2024.
Where is mediation report is there? Yes.
Mediation is fax email.
You have filed joint affidavit.
The joint affidavit final city helapra me.
No, where is that joint affidavit? Because mediation report is only one letter, small letter. What are the terms of terms of settlement?
This election at last your lordship may kindly see
at last informant submit that he doesn't want to proceed to further in the case. You have also no objection, and if the convenience is cost. That's right, but where is the terms of settlement? There is no terms.
କିଛି term ନାହିଁ. ଆଜ୍ଞା ସେ ଖାଲି
instance of opposite party number 2, FIR number so and so came to be registered against. When is opposite party number 2? You are not included that.
Nice. As per your lordship's direction, I am
included, but here it is not there.
I have filed because the file.
No, have you included? After include करती है.
notice वाला परे ही है
Administration of opposite party number 2 FIR also came to be registered against the petitioner. After investigation, charge sheet has been filed, and by the order, by improving order dated 12/2/2020, cognizance of the offence, cognizance of the offences punishable under section for 341, 294, 323, 325, and 506 IPQ was taken against the petitioner. The petitioner has sailed the said order dated 12/2/2020, passed by JMFC Mohana in number 158/200 2019. When the matter was heard, when it was referred to heard on 28/8/2024, this court relegated the parties to the mediation center of National Mediation Center. No, mediation center, High Court Mediation Center.
Yes. High
Court Mediation Center. The parties have participated in the mediation process, and the mediation has been successful. Pursuant to where is the date?
5/10.
Mediation report 5/10. On 5/10/2024, the High Court Mediation Center has submitted the mediation report, which reads again. No mediation reports. Both the parties are represented by their respective counsel, and submits that they will abide by the terms of settlement which has been explored in the mediation process. In view of taking the mediation report is form part of the present order, and the parties are bound to comply the mediation terms of settlement. In view of the mediation, in view of the mediation report, the impugn order dated so and so, so and so is quashed. Yes. Bless. Yes.
Wakalatnama I have filed kindly. The Wakalatnama I have filed, my lord.
Wakalatnama is taken note of. Already you have appeared.
No, because name doesn't reflect in
So to enter a period, then Wakalatnama is taken open. Yes. Bless. Yes, quashed.
Okay. 65.
May I please, my lords? I'm appearing to VC, my lord.
Yes.
My lords, in this petition, the petitioner has approached this honorable court challenging the legality and propriety of the impugned order dated 5th of April 2024, while which order the learned court below has rejected the petition of the petitioner dated 19th of Jan 2024 to send the disputed checks and specimen writings of the accused and the complainant to FSL.
Yes.
For examination, my lords. Even though IA has been filed for still the proceeding, the IA has never been taken up, my lords.
What is the service?
During the course of the hearing, I have on 24th of September 2024, I have filed some memo of citation, my lords.
1 minute. 1 minute.
My lords.
Mr. Pradhan, we are appearing for the
complainant in the court will be lordship.
Yes. Yes.
He is the opposite party.
Yes. You are the informant. You are the complainant. Sorry, complainant.
Complainant before.
Okay. What is the check? What is the check amount?
Check amount, your lordships, 4 lakhs each, your lordships.
8 lakhs.
Amounting to 8 lakhs, your lordships.
Is there any chance of settlement?
Your lordship, see, the accused has admitted that she has taken 4 lakhs 50,000 in case, and there is a proof of transaction of a bank account of 4 lakhs, your lordship. That is on record, your lordship. And the Honorable Supreme Court has categorically stated that when the signature has been put on the blank check, your lordships, there is no need for any handwritten experts, your lordship. The Honorable Supreme Court has categorically stated in that judgment, and that has been referred in the impugned order, your lordships. Oriental Bank of Commerce versus Prabodh Kumar Tiwari and Bir Singh versus Mukesh Kumar. That categorically stated, your lordship.
Shall I send it to mediation? Settle it.
Your lordship may kindly dispose of the matter because the already trial has been concluded, your lordship. Trial has been concluded, and this has been put for the final argument stage, your lordship. The case is in the final argument stage.
There is no stay.
No
Lords,
stay.
may I submit, my lords? Now.
Yes.
My lords, whatever the learned counsel for the opposite party submitted, save and accept the citation which he has cited. I didn't agree with any of the submission, my lords, because the trial has not been concluded first. The trial has not been concluded first, my lords. It is still under the stage of hearing. Second, my lords.
Argument stage.
Hearing. It is not argument, it is hearing. Still it is hearing, Your Honor.
Kindly see the impugned order, your lordship. In the order itself mentioned that the trial has been concluded and the
let me submit.
Argument stage. That is in the order itself, your lordship.
The impugned order is part of the record, my lords. I'll draw your lordship attention to the impugned order as well. Now, my second submission is that the learned counsel for the opposite party submitted that the complainant, the petitioner hearing, has accepted that she has taken 8 lakhs in cash. This is all wrong. Nowhere in the record. If they can show from the documents what I have submitted or from any documents from their side that I have.
Sorry, I am not conducting a trial here.
Yes,
once you are given a check, the presumption under 139 operates against you.
The voice is not audible, my lords. I'm sorry. The voice is not audible, my lords. The voice is not audible.
If you want to check it. Otherwise, I'll dismiss it.
My lords, the voice is not audible. I'm sorry.
I am just willing to settle it. Otherwise, I'll dismiss it. You have no case on merit.
My lords, I have cited some judgments of the Honorable Apex Court and other high courts. The memo of citation is filed before your lordship on 24th of September. Yes. I am citing Kalyani Bhaskar versus Miss Sampurnam, 2007, 2 SEC 258. wherein para 12, the Honorable Apex Court said the appellant is entitled to review the case of the respondent, and if the document, that is, the check on which the appellant would furnish good material for refuting that case, the magistrate having declined to send the document for the examination and opinion of the handwriting expert, has deprived the appellant of an opportunity of refuting it. It is essential that rules of procedure designed to ensure justice should be scrupulously followed, and the courts should be jealous in seeing that there is no breach of them. Second decision I am citing is T. Nagappa versus Y.R. Muralidhar, AIR 2008, SC 2010.
Yes.
Third decision I am citing, Mullahs, is of Honorable High Court of Gujarat in Special Criminal Application 11178 of 2021, titled Shashikant Kamlal Das Patel versus State of Gujarat. And the fourth decision I am citing of this Honorable Court, cited in 2018-70 OCR 51, titled Mrs. Survika Distributors Private Limited and another versus Mrs. SR Retail Zone Private Limited, wherein my case, similar to the case of the petitioner, has been covered, my lords. If the check will not be sent for expert opinion, my lords, valuable right will be extinguished. I have nothing. This is how I can prove, I can review the presumption, my lords. This is how, because in everywhere I have undisputably denied that the check is filled up by me. I have admitted the sign on the checks, my lords. But it is the contention and submission of the opposite party's complainant that the check has not only been signed by me, the check has been filled by me as well. And in using two different inks before the complainant. And in the year 2018, when I have submitted, it is in the year 2017, I have submitted, given the checks as security, and it's a blank unsigned checks.
Where is your reply to the notice under 138?
Yes. Last time as well, your lordship asked the same question, and I drew your lordship attention. The reply notice, my lords. The reply notice, page 32, my lords.
Yes.
Sorry, my lord, page 34.
Yes.
Para 3.
Yes.
That my client has received 4,52,000 only by cash from your client as handout friendly loan against which issued 2 blank checks, quite so and so, in good faith. The both blank undated checks shall be written honestly and sincerely. This is what the reply was.
You have accepted the fact that you have issued the check. Whether it is recoverable or not, this is a tribal.
Yes, my lord.
This is purely fact that actually determines the trial. The fact you should check so that I will not be get by you.
My lords, I can't hear you, my lords. There is the sound is not audible enough, my lords.
Some inconvenient question, you don't hear it. That's the problem.
No. This is not. This is the technical issue. What can I do, my lords?
It looks like that whenever some inconvenient question is asked, you are not able to hear.
My lords, see, I have a legitimate right to review the presumption, my lords. That is what I am.
Listen to me. When a notice was issued to you under statutory notice under 138 NIA, you have replied that notice. And you have very specific that yes, these are the 2 checks I have issued.
But
you have disputed the recoverability.
The writings on the checks.
Okay. That recoverability of the amount, legally recoverable debt or not, that is a question of fact. That will be decided by trial. And the trial is going on for that the checks should not be sent to the handwriting expert.
But when I agree, my lords, but my submission is that when there is a dispute with the writings of the checks and the contents of the checks,
I'll not argue with that. Let us adjourn it. I'll hear you at length. Adjourn it.
Lords,
I'll hear you at length. Next
May I submit one line, your lordships?
Let it, there is no stay. Let it be adjourned. No problem. By the time
but if the stay will not be granted, my lords, the stay will not.
The stay the proceeding. Yes.
But my lord, in that case, let me submit. Give me an opportunity to demonstrate my case.
Questions are put to you. What to do? You have to answer those questions. 66. Next.
I don't 66.
Yes. Yes. Simply adjourn to December. By that time it's over. Yes, sir.
Petitioner challenges refusal of his challenges means in fact his application for bail has been dismissed, rejected, even though the charge sheet was not submitted within the prescribed period. Your lordship may kindly turn to page 20.
Page 20.
My lord.
Yes.
1, 2, 3, 4, 5, 6, 7 lines from below. 7 lines from below. 167 2 must be your lordship will find.
Yes. You show me when you move the application.
As regards the right of the petitioner to be released under section 167(2) of CRPC as contended by the learned advocate for the petitioner, it is found on further perusal of the case record that the petitioner was remanded on 25/11/2023 and the period of 120 days to submit the charge sheet under section 167(2) of completed on 24/11/23 and the IO has submitted the charge sheet on 25/11/23.
When you move the application?
This order was passed on 8/4/24.
When you move, show me your application when you move. Whether you moved the application between 24/11/2023 and 25/11/2023. If the charge sheet, if after filing charge sheet, if you move an application on 167, then you will not be entitled to the benefit.
No, the law is what?
I am talking about the law.
I am submitting my submission.
You show me that's the law.
My lord, I am
show me some judgment.
This application was
contrary to what I said. See the cause of action for you to avail the benefit of 167 to survive till the charge sheet is filed. After the expiry of the period. Within that period you have to move application. What time? 28? 28? Then you are gone. 27. 27 you are gone. 25 the charge sheet was filed.
My respectful submission is that once the charge sheet is not submitted within the prescribed period, it is the duty of the magistrate to say that yes, you are show me from that.
Show me some judgment. Duty is cast magistrate to tell you. That is the case, then 167 to just.
This is the law in fact.
Let's see. But the judgments are otherwise.
No, even the judgments, even the apex court says, my lord, that he has to be told that he has an.
Very correct. No, apex court doesn't say. Apex court says that you have to encash the position by moving an application. 167 full. 2167.
18 to OLR.
167?
2018 to OLR.
Let us come 67, which Hon'Ble is also saying that. So let us examine it. My impression is wrong. Let us see. 167 to.
No. It's 167. 2.
Yes.
The magistrate to whom an accused person is forwarded under this section may, whether he has or has not jurisdiction to try the case, from time to time authorize the detention of the accused in such custody as such magistrate fit for a term not exceeding 15 days in the whole, and if he has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction, provided that the magistrate may authorize the detention of the accused person otherwise than in the custody of the police beyond the period of 15 days if he has satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody under this paragraph for a
total period of exceeding 90 days where the investigation relates to an offense punishable with death, imprisonment.
Rise the detention of accused in custody.
Now it is 120
This
days.
paragraph.
Now this is 120 days.
Yes.
My lord.
Now it has become.
Now it is 90 degree 90.
Again it has become 90.
And the new act it has become.
This is another thing.
That's all that.
This is under the share case.
Yes.
And admittedly, it has been filed on the.
Show me the judgment then.
Judgment.
But there are many judgments which are against.
Judgment is
900.
900, 2018. OLR 2.
When to the extent that if 167, a 167 benefit is given, and if you are not released, by the time charge sheet is filed, your detention is gone. You have to continue. That's the judgment.
I am submitting. 2018
benefit granted, you have not done case. 167 benefit granted, you have not filed the bail bond, and by that time charge sheet is filed, then you are gone.
I am.
That is to that extent
I am placing the judgment of this honorable court reported in 2018 to OLR 931.
Do you have a copy?
I have only one copy. I can place.
We have to read together. Madam, if you got a copy for sir,
and this has been upheld in several subsequent judgments of this honorable.
But the judgment order what to be. Which paragraph, sir?
Para 9.
Yes.
On the right flank.
Even though the petition have not applied. In this paragraph is directly in your favor.
Well, and this has been affirmed in 221, 1 OLR 810, 746, 164, 146, 9.
How will you deal with this? This judgment, at least see, one judgment is there in his favor, then tilted in his favor. So it's a matter of liberty. If you don't contravene it, I will utilize it and leave it.
I will verify that and if I will get something.
If you can show me some judgment contrary, then it's all right.
Yes.
Otherwise, this judgment, see, there are many judgments. Many judgments. But if one judgment is in his favor, since it is a matter of liberty, I will utilize that judgment to enlarge him on bail.
If it is some other day, I will give.
See, academic thing will do, but it since liberty is there, let us utilize this.
Yes.
Academic thing will do it. There are judgment, I am telling you, there are judgment against him also. But for the time being, since you are not able to point out the judgment, he has pointed out the judgment directly in his favor. So I will utilize this for the purpose of releasing him. What do you say?
Tomorrow I will keep it.
Tomorrow if you can get contrary judgment, okay, you can back. Otherwise, leave him.
Madam, but Supreme Court judgment is Supreme Court judgment is there.
I know you know that. You get the judgment, otherwise he is citing a judgment which is tilted in his favor. It is a matter of liberty. Matter of liberty. I will exercise my jurisdiction by giving benefit of it.
Disabled right cannot be extended for indefinite period.
But this judgment says straight away. That will not excuse. But actually, apply somebody liberty, you can't not use for that. It is first item. You show me other than utilize. Let me photocopy utilize and leave it. First item tomorrow. After vacation is coming and his liberty is involved, we can't, he's citing a judgment straight away.
It is cannot be extended for indefinite period.
But he's citing a judgment straight away, sir. You have to do it. When it comes to the liberty part, if it is slightly tilted towards the accused, the benefit has to go.
I don't know, supporting of that, my lord, and signal that.
But you have shown, I verified and gave it. I dealt with your judgment. His point also, I dealt with and gave the benefit.
If he has
Then how it will be indivisible?
But this judgment says that that will not exclude.
Supreme Court doesn't say.
First item, give a copy to.
I don't think.
72 as mentioned to be taken up at 3 o'clock.
Yesterday, lawsuit directed to remain both the party to remain liable. I have got both the party for 68 item. Compromise on the basis of then what do you want exactly? It has to be 72. 72.
Just small, but even payments can dispose.
330, yesterday, lawsuit.
No, here 69, the 330, but there I need to hear it. I'll allow it, but I have to give a reasonable judgment. Rather, I have given me judgment where it says that even in 138, if reason is there, I can dismiss in court. I have to pass this. I got that judgment. I have to read judgment. I'll reserve the judgment and in this case. Again, in your case, I'll reserve judgment.
I have given the copy.
I got that judgment. I read it.
Another man relying that judgment.
Again, 2023. I have to give reason, that's all. He's not saying that I'm your case over. What is your item number? 69. He's not coming, I can't dismiss in default, I have to pass a reasoning order. 69. Yes. Yes, what is your matter? Convenience order is the challenge. Judgment. I just give a reason, that's all. Yes. The petitioner, that is 138 case, convicted by first court, convicted by the appellate court, the revision filed, he doesn't come. Yes.
And among those two,
Whatever I am done. I am not going to all this thing, not coming also. 2 courts convicted, yes. Convenience order dated 2003. The Mr. Ponda, then give me 10 minutes. I'm writing, move on and write. And he's also waiting for some matter. Jana is also waiting for some matter. Let us see. The petitioner has to cross the order of convenience on the basis of compromise. 68 lawsuit. Yes. The petitioner is having some landed property and the opposite party is land developer. Who has given already dispute. Already dispute that is there at plus 37 and both the parties are present. What is the offense? 420. Yes, do you have any objection? No intercept between them. 420 and all. Who is opposite party number? Opposite party number is Soban Das? Yes. Suna Karbali is the petitioner. Yes. आपने सेट ले ला? कौन सेट ले ला? हाँ? आपने पैसा मिल गया? कितने? 30 lakhs. Cross कर रहे हो? Right of the instance of opposite party number 2, FIR so came to the petitioner. Allegation in the FIR is so. The opposite party number 2 and the petitioner are present in the court through their respective counsels and identified by them. They have filed self-petition copies of their Aadhaar card to establish their identity, which are taken on record. Both the parties have conjointly stated that they have settled their dispute and filed a joint affidavit dated 10/5/2024 inter alia. In this joint affidavit? Yes, your worship. Stating age under para 1, 2, 3, 4 and 5. Para 1, 2, 3, 4. Okay. On the query from the court, the opposite party number 2 states that he is completely satisfied with the terms of settlement and he has received the due amount. Therefore, he doesn't want to proceed against
the petitioner regarding head to the terms of settlement and the affidavit filed on record in view of the judgment of the Honorable Supreme Court in Gyan Singh and so and so, subjecting the petitioner to the rigors of the trial would be a futile exercise. Therefore, I'm inclined to allow the petition accordingly. So and so, cognizance or in order related so and so, and consequential proceeding arising therefrom are quashed. Yes, next.
I have already given the
Yes, you file this. Yes, next.
I don't 70.
70.
70.
Non-appeals for the party.
So 70 minutes before.
Imagine non-appeals for the party in the interest of justice at the end.
70, my lord.
You are there?
Yes, ma'am.
What do you want?
My lord, I'm challenging.
Before my lord sister starts, my lord, may I suggest item 71, the time will be there not for disposal. But that will take some time.
He is very considerate to all of us.
I think they relax their patience.
All right, I'll put it on 22nd, 23rd. 23rd. 22nd.
After that, 24th.
24th? Okay. 24th. Very important. I think that see, a lot of people are waiting. It may come before lunch also.
That is why today submitting. Because I require only 5-10 minutes time. Even that will.
Okay, put it on 24th. Yes. Item number?
Item number
71. Yes.
Interim order may continue.
Interim order to continue. Yes, madam. What do you?
My lord. The lordship has proposed a report from the vigilance. I admitted in toto.
I'll yes.
So whether after that a case is made out or not.
I'll see that.
That is also available in lordship records.
We'll see. Okay. It's up. 2 p.m. 22. 22nd. Yes, madam. What is
But cannot be disposed of. Cannot be completed. So why there is no proposal attention?
Yes, madam.
My lord, I'm ready to argue the matter. So,
but there is a pouch. The doctor time is there. That's all.
I'll just put it after vacation. Reopening, week after reopening, or let it be on 30th. 30th? Okay, 30th. Yes. 30th.
Another matter, lots of fixed. Another matter has been fixed to third.
Then let it be on 4th then. 4th. Yes. Yes.
I don't know, 72.
Yes. And what are the, how many matters are there then?
3 appeals. 3 appeals are connected in this matter. In one appeal, Mr.
No, there are totally 75 matters.
Oh, yeah, list.
In the list.
Yes.
73. Okay, then it will be hearing matter. And 74? 74 and 75 I'm simply adjourning it. 74, 75, put it in the weekly list. Okay. Now, let us see. We'll see if you can finish it up. 72, yes.
72 minutes, there are 3 connected appeals. In one appeal, Mr. There is appearing the senior counsel. He has to rush to Delhi for some medical emergency matters. If you all,
That's why I am appearing.
his associate is here. He has some relatives matters. His cousin, his nephew perhaps. He expired, so he has to rush to Delhi immediately. Yes, matters. And the rest 2 appeals, Mr. Panda and what happened?
I'm sure that his nephew has expired.
Who is?
His younger sister is based there in Delhi.
Oh. Well, I think we should not.
But then we can do one thing.
Yes.
Let us keep it to the 5th of November, Millards, at 3 o'clock.
5 o'clock.
3 o'clock.
3 o'clock, exactly. Because that is nice.
I am not saying
immediately after your meet, because the Diwali and other things are there.
Yes.
And I am also back.
Fifth then, huh?
Fifth of November.
Mr. Rajvi.
Well, it's can it be on 7th, my lords? Subject.
Okay, 7th and 3 o'clock.
Yes, my lords.
And see, prepare the note and
That's the only problem. Unless my
when your judgments are reserved, you don't give your note. While dictating the judgment, I'm taking so much of
tomorrow.
Well, I will be able to give the reply unless my learner seniors have to reply them like, no, something I'm giving you reply. Yes, my lords.
advance copy. Yes. Both the news will matter on 7th at 2 o'clock. Both the parties to exchange the written submissions. Written submission. And it made clear that no further adjournment shall be given.
Appeal number 80. 80/2011. The IA number 7703. The applicant sole applicant died. IA.
I allowed.
Maybe allowed.
Yes. This one appellant in the present case is expired. Therefore, who will file the application? Wife. The wife of the deceased appellant. Wife and the son of the deceased appellant has removed the application under 394 CRPC for the reasons stated in the application. The same is allowed. The newly
consolidated cost statement.
Included appellants directed to file a amended memo of parties. Leave the matter on 7th.
No limit.
No.
Yes.
Grateful.
Okay. 73. 7th November at 3 o'clock and exchange the written submissions. Yes.
In the meantime.
In the meantime. Yes. Yes. No, 73 is there. 1 minute, 73. One matter is there. And let us utilize the 10-15 minutes if possible. Yes. What is this matter?
This is a matter of vigilance case. I am convicted.
Who is appearing, sir, here?
Mr. Sanjay Kumar Das is dealing this matter. I think in the morning we made a mention that the Lordship has said in that. So I'm so sorry, I don't know about it. So I will inform us.
Give little idea what is the case. If it is small case, then I'll proceed. Yes. Let us, Mr. Reddy, let us take the idea.
Yes, ma'am.
Not hearing matters. Because we have 10 minutes, we can to get an idea.
Case where the appellant was convicted because he was working as a clerk and he allegedly asked for 3,000 rupees and that was allegedly paid and vigilance was there, then he was caught with 3,000 rupees.
You have the file with you? Hard copy is there? Yes.
I can give my copy.
Give hard copy. Good copy. 73.
So I'm giving my copy.
Extra copy you have? Yes.
Then not extra.
Give me that file. अरे यार इतना बड़ा ये ऊपर वाला तो you say small case such a big file. Yes. Let us go on.
It's very small case.
Yes.
That way I'm giving the written argument so that my learned can take the benefit out of that also, and your lordship can help.
Can we have a glance at the written argument? It's more than the
judgment so that the lordship cannot bother to see the.
No, show me the this is a trap case.
No, it's not a. Actually, it is allegedly to get trap case. It is not a trap case.
You show me demand and show me acceptance. Finish it up. It should take more than 10 minutes.
Yes. It is a trap case because section 7 is there. 7.
Yes.
I'll come to that.
Yes.
What happened in this case? The complainant, Santosh Kumar, he was appointed as an attendant in the rehabilitation assistance scheme
in 5/6/2007. He was not paid for salary for 4 months. I was working, I am not connected to this. And CDMO has specifically passed an order not to release this salary. So I was not in a position to give any benefit. I'm not connected, I'm not giving any benefit. I cannot give the benefit because CDMO, the head of the organization, has been practical. He visited me, he was angry with me because I was clerk. She thought okay, I can do something for him, but I am not. Secondly, that two issue. One issue that was there. Second issue is that the sanction. That sanction is not given by the CDMO. It's the appropriate authority. Sanction was given by superintendent. And superintendent categorically in his deposition said that I have not seen this, I have not done this. This is whatever the document given to me. This. So question is under section 7, whether I am capable or competent enough to give any benefit out of that.
So maybe CDMO's letter, which exhibit.
Even if he is not competent to give section 7(1)(d) is quite clear, your lordship note. Even if there is no one, but he gives an impression that he is in a position to do that work, still he will come under the section 7(1).
That is the one facet of argument.
Yes, ma'am.
He has given an impression that I am capable of doing it.
Yes.
That's the one demand is proved. Demand is proved. But he says that I was head clerk. There was a direction from CDMO not to pay the salary, and see this the attendant is asking for 4 months salary. In lieu of that, 3,000 rupees is demanded.
Yes.
Let us see the letter. What is the terms of that letter? Where is that?
That is exhibited, but the trial court record has come here before.
Show me which exhibit is that?
Before that, I saw that
CDMO letter, exhibit 12.
That's
12/1.
That has been
not a part of the paperwork. Exhibits are not a part of the paperwork.
Exhibits are not, depositions are. Depositions.
And your lordship knows Syed Ahmed versus State of Karnataka 2006 Supreme Court. There also we have reiterated the solution that even if there is no work pending, still subsequent judgment will come under 7(1)(d).
I saw that. I saw the judgments also barely because that if there is money has been given, that does not ipso facto take away the right to defend, and if it is not eligible or competent enough to give any benefit anyway.
Same submission is reiterated. I have already given the reply to that.
That is section 7(b).
Yes.
Section 7 section.
Section 7(1).
1 minute. Let me see the exhibit. See the exhibit. If that is your case, first of all, you show me that exhibit. Exhibit 12. What is the language there? It's up exhibit. Exhibit 12. Come to exhibit 12.
Chemical examination is also positive, my lords.
The acceptance is there.
Yes.
Only the demand part we have to see.
Yes.
7.
And my lord, so far as the submission regarding the sanction is concerned, my lord, so lordship knows Paul Varghese versus State of Kerala's 2006. Yes.
9.
That has to be raised at the preliminary stage, and if raised, they have to establish how they are prejudiced. Where was the failure of justice?
That I'm sure definitely don't. What is your document?
What is the language of non-patient?
No, he was appointed illegally, so CDMO consciously passed an order that no salary should be released. That is there.
Then?
So salary should not be released. So
should not be released. That's the language I want to see.
Yes.
She said the document. See, the fact remains that she was working. If she was working,
You might have given the impression that you will get the facilitate. That's the whole difficulty. And if your lordship has the 313 statement, the difference that I get the hurdle got a head work even. And even the 313 statement, it's denial simpliciter. If your lordship may kindly have a glance at.
So burden of proof hastings cannot be accused.
Yes. Proceed. I am getting that.
So the trap was set and that 13(2) and section 7 with corruption charge was fastened on me. So your lordship kindly see section 7B for a moment.
That exhibit will not help you. That exhibit goes against you.
But it is clearly there. Also.
That will not help you. Yes.
Reproductions also.
Yes.
Section 7D.
And even if that exhibit according to you is there, according to me that is not there, I read it. Even if it's there, and you are not capable of doing it, section 7 is crafted in this manner.
Yes.
You have given impression to someone, 7 months written, though you are not capable to do and get the money from them. The language is demand. That demand is also
Yes. That can be just
very demand.
intention that I'll come to that.
Yes.
By one. You'll also kindly see the section 7.
Yes. 7 is there, yes. Reproduce here. In Indian literature.
D. Section D. Subsection D. A motive or rewarding for doing. A person who received a gratification as a motive or reward for doing what he does not intend or is not in position to do or has not done comes within this expression.
You are not in a position to say
against myself to that answer.
Yes.
So the payment of salary was withheld, it is the conscious knowledge of the complainant. It is not that he straightway is innocent, he does not know anything. I am capable to give something, the doctrine of prospective notice. That is cannot be there because he has been there, that he is within his knowledge that I cannot give anything, I cannot override the order of this medium. And I am not a helper. I am not a helper. I am not a helper. So then for that also there is judgment. So I have in the written submission I will hand over all those judgments.
Yes.
So question is second proposition is here, Lord see. But whether the
period 1 is okay. Decoy customer, decoy informant. Period 1,
It's not legible even, my lord. It's very difficult.
Santosh Chao Patnaik. Period 2. Period 2.
PW1 is
Is there? Evidence is there in front of me.
Santosh Chandra Patnaik.
Chao Patnaik. Santosh Chao Patnaik. Yes.
So then the second part is the question of
Yes, regarding the demand even. If your lordship must see the first paragraph.
there is no direct evidence on that. So I come to the depositions also.
Yes.
You take away my all rights and give me handover forcibly some money and you are the court in there. That Supreme Court already had.
Why have you accepted the 3,000?
No, that is he has given just pushed the money. He has pushed the money because the Honorable Supreme Court had in 2014 I have shown the judgment also. That's because there is
Who's the money? Where from it is recovered? From pocket?
no, it is terrible because it's a truth.
Chemical work was positive. When it has been kept on the table, then how the handles is
the case. So I just putting my hand on it, that impression will come.
Yes.
So that is one aspect. I come to the depositions, everything. Second aspect is the sanction. So sanction, CDM, superintendent, the was superintendent and the CDMO in the hospital are two different aspects. CDMO being head of the institution and he has the passed the order not to release the money because of some.
No, sanction, we are talking about sanction.
I'm not to sanction. So this CDMO, how I prejudice that I mentioned, because if the CDMO has not sanctioned, if I have taken that.
Who is the appointing authority?
CDMO. So if sanction given by not by CDMO, then I am highly prejudiced. How I am not prejudiced? Because superintendent which world he will be doing everything. Then your lordship kindly see the depositions of the superintendent. That starts from page 79 and the ultimate paragraph is page 83.
Yes. What is your stand in 313?
Hello, I was just about to say that. The last question.
I'm just searching.
Yes, ma'am. The Lordship has got it.
Where is that?
My lord, that is at page 41.
In the, yes.
Page 41, question number 38.
Yes. Read it out.
Do you want to say anything about this case? Ragore case ଦେଇଛନ୍ତି CDMO तार अपॉइंटमेंट इलीगल करी कहिथिले ओ दरमा बंद करिथिले. Where is about the thirsting of money matters here? No way.
No suggestion. No suggestion. Any suggestion is given.
313 what section क्या दिया जाए? 313 what suggestion?
No,
it's very strange.
It's not the court examination. You are putting you that. See, you have to put up your case in 313 and substantiate in the defense evidence.
Yes.
And put the suggestion to the at the relevant time. On the basis of suggestion which you have put, that should reflect in 313 and defense evidence. That is how the process continues.
Yes. Yeah.
Your case, when the prosecution evidences are examined, you have to put your case as a suggestion. And that should reflect in your 330. And substantiate through
that finds corroboration of later evidence.
May need once more the
that is how the 313s are.
I have to read the total
entire evidence you have read.
Please, Lordship. Your Lordship, if Lordship read again, Ragore case ଦେଇଛନ୍ତି. Ragore case ଦେଇଛନ୍ତି.
Acceptance.
Acceptance.
How will you get out of the acceptance?
That is said.
Michakata is regarding
defense. You have to tell your defense. You say that reports will be given to you. How have you proved it? It is a rebuttable presumption.
Section 20.
Unless you prove it otherwise, that
I am so obliged. Section 20 presumption.
Section 20.
Yes, 20 it is there. But I am saying if prosecution is not able to prove that my action is connected to my accepting my bribe, read with the situation, seeing the whole the case. If he is working, not that he is from outside, that complainant is not from outside. It is he is the
which in section 7, the tests are different. Tests are, they have to only prove the demand is there and the acceptance is there. And presumption operates against you.
Yes.
And you have to rebut because it is a rebuttable presumption, you have to take your stand and prove it. And insofar as the demand, if the 3,000 rupees is concerned, through the PW2, this position approved by them. And acceptance, there is a raid party and they have apprehended you and the money is recovered from you. Your position. Then this demand and acceptance has been, according to them, they have discharged their onus of proving. And you have to disprove it.
Prisoners.
Disprove it.
This same proposition was in Dr. Balkistan case by Supreme Court 2001. Where it is once the premise is established, the interference to drawn is that the said gratification was accepted as motive or reward for doing or forbearing to do any official act. Here it is not been proved anything that I have taken anything, even if I go by that presumption.
Yes.
Even if I go by that presumption that I have taken this money was first on me.
That's in fact, my learned friend will not dispute regarding the factum of demand, I think.
Demand, I'm saying that there is cannot be any demand because I don't.
I understand this because PW is here is there. PW, in fact, my lord, this is one of the rarest of rare cases, my lord. It appears to be very watertight. Even the overhearing witness has amplified.
Generally,
Yes, hostile. If you're not generally come to page 58. So 58. Witness. Yes, my lords. Page 58. So one of those rare cases, my lords, where I could find this.
Just because money was that's people already said that's
not that.
Yes, my lord. 58 your lordship mechanic. Yes. 58 is the relevant paragraph. Relevant page. The accused was sitting. First line, my lord. Page 58, first line.
No, which paragraph?
I am reading from that page, my lord. Page 58 because
Read it.
accused was sitting on a chair in a room situated to the backside of his office room, and medical bed was lying near him. When the complainant went to the accused, head clerk was accused, asked him if he had bought the money, and the complainant told that he had bought the money and bought out the money from his shirt pocket and gave the same to the accused, who accepted the same, and well, it's not legible. Counted the same in both his hands and put the same under Dharutri newspaper on the medical bed. What more?
Why have you counted?
Yes, can you see the classification?
You have a difficult case.
Your lordship, can you see the
After seeing the meeting, then I'm on the record.
We are just getting an overall.
After seeing this meetings, I'm getting jealous of Mr. Sanjay Kumar that he's getting good cases. Hostile most of the times, even the decoy time hostile.
Generally, what happens is decoy witnesses support the case, and overall witness invariably 100%.
Yes, 99.9%.
And there are prosecutor cases.
it is a now a norm.
Case for you to argue.
It is a norm that vigilance has to give 10 cases per month. So they have to trust somebody now. That is there. That is the to show that the
You have a very difficult case. And you could not put forth the right defense.
Yes.
And which is not germinating from your 313 statements. And I don't think you have the defense evidence also.
He's innocent appellant himself counted and kept it. He's very innocent.
It is so. Then it should be remanded. But I have a, I'm sure your lordship has a very good.
Very good question of remanding appeal. Even you, why remand?
If anything is, there is a gray area. In your lordship. That is sure there is no gray area. That is very good case.
It's not remanding. If the appeal has to be heard, yes, on the basis of evidence and finish it.
That's your lordship.
Yes, I will put it then some hearing.
Let Mr. Sanjay have the advantage of arguing this matter
and shorten your this thing.
Yes, I have prepared a written argument.
But written argument should be smaller than the evidence. Confining to 5-6 pages.
So I will do that. Because it is a double space, so it will
Let us see. If written submissions are thicker than volume, we gather those papers. I put it in the first week of November. First week of November, suitable date, yes.
Rather becoming a convenience note, it becomes an inconvenience.
No, that's invariably happens here. It's very difficult. And let it be on 8th.
8 is not Monday or Friday.
And then come on 14th then.
Yes.
14th will be better.
Your lordship is 6th November.
6th, there are some matters.
Yes, normally 3 6 matters.
5th. Okay. 5th.
That was in 23rd, 24th, fellowship.
23rd, 24th, full. Again, you will come and wait, nothing happens. Today, discharge the board will handle so that I could hear it. I got a complete idea about the matter. We'll see. Yes, yes.
Please, Lord. So your lordship putting it in fifth.
Yes. 61.
It has been actually from December. The public it may be fixed someday in November. Otherwise, I'll be missing the value.
Okay. No more last week. No more last week. Yes. Non request, huh? Don't write non-present, non-request. List it on last week. Yes. Any mentioning? Okay. Thank you.
Yes,